करिवे बा जोडा का अर्जन करि परिवे काना बहुत टाइम पड़ेल हंती सो दैट वे यू कैन आल्सो मैनेज द लिस्ट
ने मोर एकटा मु करिवि लंच पर होछि लंच पर
तो पेज वाइज कर दियंतु मेडिसिन में केटा
मेडिसिन सर मेंशन करली कनेक्टेड केस टा आसी टिके प्लेस करियार अछि लंच पर प्लेस करी
मेडिसिन आपनकर अछि अच्छा फास्ट मैटर
रे ओल्ड आसला मेडिसिन पई तासने गोटे टैग ही न्यू मैटर भी आछि टिके हेटा लंच पर प्लेस करी
फेयर इनफ
आई
आइटम पेज टू आइटम 3 to 15
3 to 14 page 3 15 to 22
item 20 all ships. This case, notice was issued to the 1 and 2 your ships. 2 is the minor, repeated by mother appointment of 1 your ships. So I
requisites तो दीटा जीवो बोधे
वो गुट्टे फाइल करिछि minor तो
my understanding is that requisites दीटा जीवो सीए दीटा जाको रिसीव करिवे
then I will file another.
Mr. J.K. Mishra, I think agrees with me. अपन जो रिक्विजिट फाइल करिवे तो प्रॉब्लम एठी होची यू आर टेक्निकली यू आर करेक्ट छोटो पिलाटे अछि तार मां अछंती को डायरेक्शन करले बिकॉज़ से पार्टी अछंती यू आर सेइंग यदि मां को दिया हला दैट इज एनफ यू आर राइट टेक्निकली किंतु नोटिस जो रजिस्टर कोन से क्षमता अछि की तापर से तापर बड़ होई जिवे धरंतु जे 17 रे अछंती 17 वर्ष
6 वर्ष
गोटे एग्जांपल अपन 6 वर्ष रे कोन बुझचंदी वी शुड नॉट बी दैट अनरियलिस्टिक 6 वर्ष ऑब्वियसली से किछि बुझु नांती गोटे छोटो आ गोटे 17 वर्ष रे पिला से मेजर हे जिवो सो देयर आर सो मेनी इश्यूज आई थिंक अपन रिक्विजिट्स दिके ना गोटे एड्रेस रे जिवो सो एंड सो रिप्रेजेंटेड थ्रू द मदर गार्डियन मिशन इज थिंकिंग जे एग्जाम कर देल हबो कि मोने एग्जाम कर देले प्रॉब्लम हे पारे सीए माइनर 6 वर्ष छुआ पे रिसीव करिवे अपन डिस्ट्रिक्ट फाइल कर दियंतु बट माने पोस्टल लिक्विजिट गोटे खोल कवर गोटे कॉमन जीवो ना दुबीटा कवर जीवो so and so represented through so and so right
then I will file your order.
correct I'll pass how much time Mr. Das
yes lordships I will
time kete samay lagiba apanku
by next week lordships
within 7 working days
yes sir
I'll pass that order
yes lordships
yes
Your Lordship, item number 22.
acha sorry 22 yes please
Requesting Your Lordship for an adjournment.
Notice have you read the check the cost list notice read no notice it says neither ready nor answered notice yet returned
so my lord I am in DC my lord in item number 22 my lord
अपन कोन एंटी पढिलेनी कोठी अछंती की फैन
no my lord I am in my office room just near
अच्छा आ भल जगह रे अछंती तो ठीक
है in a close room my lord I am in there
मैं जगह तो भल दरकार ऑब्वियसली
नहीं ठीक अछि
no work remaining present in the court तो ठीक अछि yes what you say sir you are appearing
my lord I have appeared in this case my lord
केबे ओकरत ना फाइल करले
I have filed on my lord
अच्छा अपन ना अछि हां yes तो सेटा एटा रगड़ सागर सर मिसी जाई छै अच्छा अपन होचंती अलंग विथ मिस्टर जेना प्रभास चंद्र जेना
my lord my name is Abhijit Manti
अच्छा ठीक चल से अपेयर कर से केबे डेट करो क्विक अपन या तथ्य भी है 24 मिस्टर महांती
my lord high dispatch my lord
24 व्हाट द डेट ना थैंक यू यस आप मेंशन करथिले मिस्टर सामल
yes I think 29
अच्छा नेक्स्ट पेज 29 सर
next week
हे परिबने आप नोटिस मैटर टिके लिबरल होंतु टे टाइम दियंतु देखियो ठीक अछि नोटिस जाई छी 27 वी कमेंटिंग 27 सिंपली पोस्टिंग होछ हला कंप्यूटर रे जाउछ मिस्टर मिश्रा प्लीज 34 yes
I am for the open over 1 to I have
yes 34 टा पोस्ट कर दियंतु 26 मैटर
वी काउंसिल 4 ता
हे परिबने आगुआ इस पर्यंत कंप्यूटर तो पळेबो वेरीफाई yes okay so we'll start commence the proceeding after recess
My lord, my lord.
Tooth service.
Yes.
Earlier occasion in similar orders, my lord.
Amnesty scheme रे दिबा
Amnesty
अच्छा amnesty scheme आसी जाइए अपन चिट्ठी आसी जाइए
Chitti, my lord, that scheme has been floated, that we know.
हाँ,
And
हाँ.
we have, my lord, for that we have filed one IA.
No, Mr. Ray has no difficulty, but one part what he is asking, I mean, very pertinent also. They are saying that it is case specific. Mr. Ray's contention is that because my expectation is that all the matters should at least be considered for amnesty.
All the matters filed before 31st March
Mhm.
2025, and this case is coming under that category. But
Okay.
They have not applied for amnesty till now, as per my friend's
So,
statement.
Mr. Ray, you are issuing that letter indicating amnesty.
Each and every employer.
So that is my understanding. But you are saying now that they have to apply.
I mean, we are informing them that scheme is
Acha.
such and such.
So you are receiving it, they are applying, then you are issuing the letter.
My lord, my lord.
Okay.
It's the similar order and.
Yes.
putting over.
But Mrs. Patnaik, just look at this. So because they have told it's case specific, and of course utilizing technology, so I'm scanning that scheme so that they are also confident that what they are doing. But in your case, this scheme is not letter is not there. But since Mr. Ray is saying
Yes, ma'am.
the cutoff date, this case comes within the cutoff date, so that has to be there.
My lord.
My only submission is that portion which has been.
I
annexed,
got your point. I've
that-
asked this order, but I cannot reflect this. Nor I can refer to any letter. What I will say that it is submitted by item referring to.
ଗୋଟେ ଜିନିଷ ମୁଁ କହିବା ପାଇଁ ଚାହୁଁଛି ସେଇ ଯୋଉ ଲେଟରଟା ସେଥିରେ annex ଅଛି they have filled themselves not issued by anyone. My lord, I have also annexed this letter. Kindly have a glance. Similar, पूरा similar. ସେମାନେ ଖାଲି fill up.
ଆପଣ ଚିଠି ପାଇଛନ୍ତି because you said that ଆପଣଙ୍କ ଚିଠି ନାହିଁ ବୋଲି.
ନା ନା ଅଛି ଆମେ ପାଇଛୁ ଆମେ ଲଗେଇଛୁ ଆଇଏ ରେ ଆଜ୍ଞା ଦେଖନ୍ତୁ page 12 ରେ ଅଛି
then I could not construct your words properly. ଆପଣ ବି ଆଇଏ ଫାଇଲ କରିଛନ୍ତି.
ଆଜ୍ଞା
ତାହେଲେ ଠିକ ଅଛି ସେମ୍ ହବ.
ଆଜ୍ଞା
ଓ ଆଇଏ ଆସିନଥିଲା. ଆଚ୍ଛା I will pass that order.
ଆଜ୍ଞା ଗ୍ରେଟଫୁଲ
ଏଇଟା ତା ଦେହରେ ଲଗେଇକି ଦେବେ.
ଆଜ୍ଞା
ଏଇ କପିଟା ରଖିଲେ ହବ ତ?
ହଁ ହଁ ଆଜ୍ଞା
Mr. Ray, you have seen this.
My lord.
ଆଇଏ କପିଟା ପାଇଛନ୍ତି.
ଆଜ୍ଞା
ଆଇ କପିଟା ଦେଇନାହାନ୍ତି।
ତାକୁ ଦେବେ ନା.
no.
So that is he also in fact he is as good or as bad as me. So he was also not sure what is. Okay.
ଏବେ ଆଉ
ଏବେ ଆଉ ଗୋଟେ ଦେଇଦିଅ.
ଦେଇଦେଇଛି ଏଟା ଲାଗିଛି ସେ କପିଟା କି ଯୋଉଟା ଆପଣଙ୍କୁ
ଆଇ
ଗ୍ରେଟଫୁଲ
କର.
Item 1,
Item 1,
Yes.
this 18941 came for pending for mediation. But Tala Kotre, the CP is going on. Whatever has happened from that, I can gather no useful purpose will be served so far as the matter being referred to mediation is concerned. That is one part of it. Then the second part would be, ମୁଁ ଗୋଟେ କେସ୍ ଫାଇଲ୍ କରିଛି ଯୋଉଟା ମୁଁ ମେନସନ୍ କରିଥିଲି your lordship was pleased to bring it. ସେଇଟା ହେଲା ଯୋଉ other case my lord it is there on board before your lordship 6203 of 2025. ସେଠି ସେ ଯୋଉ divorce proceeding ଟା your lordship that is going on before the court below, I had filed a petition for bringing on record the documents that your lordship will kindly turn to page 30. Page 30, my lord.
Page 13 WPC.
WPC 6203 of 2025.
Okay, I'll get to that file. Just a second. 6203, page 30.
Page 30, order dated 13/4/2023.
13/4, page 30. 13/4. Yes, advocate for both the parties.
Both the parties filed Hadira, counsel for the petitioner files petition under section 30 read with 13(1) of
13
CPC.
are read with CPC.
Maya. Say
13, what is that 13R1?
Seta tapore asila your lordship will kindly turn to the next page page 33.
Salary statement produce करिए.
सेटा deal है page 33 रे.
अच्छा.
Your lordship will see the learned court below has referred to order on 13/4/2023. Lordship got it, man.
Correct.
The husband petitioner has filed petitions AIA direction fine. And I wanted to prove that wife has also income for the purpose of final adjudication as to the alimony part of it. Now, the court below deals with it. Your lordship will kindly
This petition is a section 13 application. Main petition is 13.
Yes,
13 filed
by the husband.
by the husband. Okay.
Madam, that is annexure 1.
24 has been granted.
24 has been granted. 24 was challenged by me. Your lordship directed early disposal of the proceeding. 24 has been challenged by her, which is that item, the other item, which is listed for mediation consideration. Now, in the meanwhile, this application, because the proceeding was going on, my lord, this application was filed. Now, the land trial court at page 35, paragraph
CP is
3.
still pending.
No, it deals with the same. In paragraph 3 at page 35, I beg to point out that to your lordship.
35.
Page 35, paragraph 3.
Yes, paragraph 3 in view of the above application.
The application, submission made by both the parties, oral objection by the land counsel for the respondent wife, and written objection filed on behalf of the respondent wife on so and so. This court feels that before calling for the above documents, the respondent wife should appear for her cross-examination to answer the above points raised in the petition dated so and so, stated in para 1 of this order. Para 1 re my lord details ra lekha heichi. So the petition mentioned in para 1B of the order is allowed. All other petitions shall be considered after the cross-examination of respondent wife. तेणु जिते गुड़े प्रेयर था 1B टा खाली कहले रिकॉल करने फॉर क्रॉस एग्जामिनेशन रेस्ट ऑफ द थिंग्स दैट इज जोटा आम कहलु इनकम से रिक्रॉस है कोर्ट ताको देखिए क्रॉस एग्जामिनेशन आम जो डॉक्यूमेंट प्लेस करूँ कोर्ट विल कंसीडर आम वी हैड ऑब्टेन द कॉपीज एंड फाइल इट नाउ द ओरिजिनल कॉल फॉर हम कि नहीं डिसाइड करेंगे. Now what happens, your lordship, thereafter she did not appear. We prayed that distress, because the court has to compel appearance for the purpose of ensuring justice. That was done also, nothing happened. A recall petition was, she filed recall petition was also rejected. Now we filed a petition under Annexure 4 at page 39, your lordship will see. Therein, page 39, Annexure 4.
Yes.
Same thing we reiterated with regard to her income and everything. We also said that she filed application for modification that was not entertained, and therefore it should be considered because she is not turning up. Now the learned court below rejects it, saying, but this runs contrary to his own order that it will be considered. At page 44, your lordship will see order dated 4/11/2024. He says the case is a targeted one. My lord, target है जो मु 24 application challenge करतली. The Hon'Ble court was pleased to dispose of, saying that the case will be disposed of. But that doesn't mean that the relevant application you have kept for consideration is to be all obliterated. The Hon'Ble court never says that that will not be considered. And you said it should be kept pending for consideration. Now he says it is rejected. I am not inclined to entertain and reject it. That is how I am before your lordship.
Since the other petition, here notice has been written unserved.
Again.
The other petition is there. The learned counsel is not appearing. Otherwise, we could have requested him to obtain instruction at least. He may not appear because you can't compel someone named learned counsel to appear.
My lord.
So it has to be no choice. It has to be adjourned. BK Rathwa, could you find him? Inform him.
नहीं सेटा टिके मत लोकेट करे को असुविधा हो.
Okay, so what I will direct in this matter where no one is appearing, I will simply adjourn it along with the other matter. In the other matter, I am directing the next date shall be communicated to the learned counsel for the petitioner. Where she is the applicant.
Here I have a prayer. It's I think subject to correction by your lordship. It's got observation thila je if a petition for time is filed, that will be considered.
Who
case tare.
6262
हाँ मुझे ऑर्डर से पाइनी
से पेपरलेस से देखि दियो
से एंगेजिंग काउंसिल को थू
ऑर्डर नंबर 1 टा टच करंतु बुकमार्क रे कलम रे ऑर्डर टा टच कले देखा दियो आसीयो
My lord, your lordship will see order dated 11/4/2025.
गोटे पुस्तक गोटे पळेलाणी आपण
My-
फिजिकल I have the problem of the third page is missing in my brief.
हाँ एठी भी नहीं किंतु से लिखिले however liberty is granted to the petitioner to move an application over requesting the सेठी रहि गला तापर पेजटा नहीं
फाइल काढतो आगे पेज 3 टा काढतो ऑर्डर नंबर 1 पेज 3
आउ सडकु नाही केमती स्कैनिंग हेनी
से माने टिके देयर इज अ ह्यूज प्रॉब्लम दो वी हैव
I think this is
we have been trying to train them for the last more than 2 years.
किंतु जहाँ भी है
Many times I have tried personally also to train them so that in the sense कि I train the trainers जे अपन ताको बुझांतु because they
नहीं जेतिक भी है किंतु गोटा बहुत बड़ कथा है
बहुत बड़ सॉफ्टवेयर
माने ए जो जिंसटा है
बहुत
बिग थिंग टू हैपन
big thing. It's a big thing, no doubt.
कोठी टिके भूलभाल रह जाउची किंतु
से माने जेतु they don't understand सेवन तो हाई कोर्ट स्टाफ नहंती से बुझी परनांती को जिंसटा कोन
आगे एंड आई
से माने सब थोड़ी लेक्चर रीड पिटिशन को एमएटीए को भी रीड पिटिशन
एट टाइम्स ताकर अमेनेबिलिटी भी टिके कम रहउची
हाँ,
तुम फील करनांती
हाँ।
जो ताको ऊपर सुपरिटेंडेंस ता टिके
इधर नहीं एकटू आगे लिखंतु WPC 6203 of 2025 हैला
ग्राउंड फेचिंग थी
एकदम सुपरिटेंडेंस अच्छी एक्चुअली करा होची कि जेतले लार्ज स्केल बा मास स्केल रे करा होची से जितसटा सो सी टोटा प्रॉब्लम होची आपण कोन जने सुपरिटेंडेंट जने एसओ जने डीलिंग असिस्टेंट केतेटा फाइल दरचोंती ए माने सब जगह फाइल दरचोंती एंटायर हाई कोर्ट रो फाइल दरचोंती दैट इज द प्रॉब्लम
एथरा
सेते एम्प्लॉयमेंट करी होबन
आज्ञा
आपण माने पैसा सेति की देकी सेति लोक रखी करी होबनी जे
एटा आउटसोर्सिंग नले भी हबन
हरकुलियन टास्क
6203 रे मु कहउथिली should I be permitted to serve copy on the council appearing in the family court?
So in his absence, I will not direct that, but I will pass the interim order, and what I will do that I will list that matter to inform Mr. Ratha.
सेटा
So then we can think about something.
नहीं मो
So obviously interim will continue. I mean interim is no difficulty.
नहीं मो मैटर टरे should I be permitted to serve copy?
No, I understand. I have answered that before you said this. I said I cannot compel him to accept notice for the particular client if he is unwilling. The lawyer is. I can't ask the lawyer.
नहीं वर्तमान जे सीपीटा करछनी
I understand. जे सीपीटा कोठी करछनी
एठी कटक फैमिली कोर्ट
आपण कोटा देबे
मो पिटिशन टा कॉपी देले काले से
एटी तो आपण रीड पिटिशन अछि आपनकर शुभदर्शिनी मिश्र इज ए पिटिशनर इन द कनेक्टेड रीड पिटिशन
नहीं से अछन जे
so later counsel come I will ask him that he appear if he says that I will instruction he will say that yes I will appear in some cases they are reluctant especially in matrimonial matters maybe as a strategy they are reluctant to appear I mean
the moment this income part has come she has started avoiding she was rigorous
she will not read Rajneesh versus Neha that income of wife is immaterial for determining but it will be a factor
yes
so से तांको 10,000 पाया कथा 5,000 देबे
exactly
किंतु तांको की से भाब देछन जे मु जदी माने नदी भी पारंती of course but how can she get out of it many times the strategy is that here the wife wants that she will get out of the situation impossible to getting out of a litigation after entering into it so husband को strategy ला हमें किसी दबुनु
सेटा हे परियो
so it is happening not in this case तांकर से गोटे जिंस बुझछन मंत्र हमें दबुनु so that becomes a problem for a adjudication लोक दायित्व कहला आगे दे परिबिन मु सेटा आगे तो सेठी कहि होता जे मु आपनकर सेटा नाही आईन रे आपन करचंती ଆପଣ ଦ୍ୱିତୀୟ ବିବାହ କରି ଗୋଟେ ଛୁଆ ହେଲାଣି ଆପଣ ପ୍ରଥମ ସ୍ତ୍ରୀକୁ ଦେବେନି କହୁଛନ୍ତି ତା ବି ବୁଝେଇଲି ମୁଁ କହିଲି ବହୁତ ଡିଫିକଲ୍ଟ ଆପଣ ଡିଫିକଲ୍ଟ କେସ୍
ସେଟଲ ନ କଲେ ଇନଭାଇଟ୍ କରିବେ ଟ୍ରବୁଲ।
obviously it goes on ଆପଣ କେତେରେ ସେଟଲ୍ କରିବେ ସେଇଟା ଆଉ ଗୋଟେ ଜିନିଷ
ଆଜ୍ଞା।
but they are just simply avoiding 6203 ଲେଖନ୍ତୁ as directed by this court earlier in the connected WPC 18941 of 2019 by order dated ସେଟା ଆପଣଙ୍କର ଅର୍ଡର ହେଇନି ଖାଲି ଆପଣ ମେନସନ କରିଥିଲେ
ମାନେ
ଆପଣଙ୍କର ଟ୍ୟାଗ ହବା ପାଇଁ କୋଉଥିରେ ଅର୍ଡର ହେଇଥିଲା
ଟ୍ୟାଗ ହବା ପାଇଁ 18941 ରେ ଅର୍ଡର ହେଇଥିଲା।
କୋଉ ଅର୍ଡରଟା
ଲାଷ୍ଟ ଅର୍ଡରଟା ବିକଜ ସେଇ ଗୋଟିଏ କେସ୍
ପାଖରେ ନାହିଁ
ଅଛି
ଏଥିରେ ନାହିଁ ଆଜି ଗୋଟେ ସମଥିଙ୍ଗ ହାଜ ହ୍ୟାପେନ୍ ଦ ଡିଜାଇନ ଇଜ ଅଦରୱାଇଜ ପ୍ରୋଭିଡେନ୍ସ ଇଏ ବି ମିଳୁନଥିଲା
ସେଇ ଗୋଟିଏ କେସ୍ ଆସିଥିଲା ମୁଁ ମେନସନ କଲି ଏଇଟା ଆସୁ
73 ଅର୍ଡର ଇଜ ନଟ୍ ହିୟର କଣ ଲେଖି So, 18941 of 2019 by order dated 7/3/2026, the writ application has been listed along with the said writ application. Stop. Office note put up indicates that notice issued to the sole opposite party has been returned unserved with postal report. Addressee left. But postal report within court. The postal report has been placed on record marked at flag B. Hala. Full stop. The Lord Senior appearance Mr. Samir Misra, Senior Advocate, along with Mr. Anubhav Mahakud. So Anubhav Mahakud for the petitioner, opposite party black. Appearance. It is submitted by the Lord Senior Counsel that earlier by order dated 11/4/2025, interim orders were issued regarding adjournment of the matter. On perusal of the brief available in the scanned copy, page 3 of the order is missing. Stop. The matter shall be placed before the learned registrar judicial, who shall instruct the concerned person dealing with scanning to do the needful. From the physical copy available, it is seen that interim order in the interim, it was directed that if a request is made for adjournment of the matter, no adjournment no. But to pronounce the judgment till 21/25. Well, court कर देते better होगा. कौन लिखेगा? No. The coordinate bench had directed by order dated 11/4/2025. Thus, quotation रहेगा. However, liberty is granted to the petitioner to नेकी 21/4/2025 for hearing. तापर कौन है लाए? Pronounce ही नहीं.
नहीं से केस पेंडिंग अच्छी डेफर होची. आज मु आज ही
the Lord Senior Advocate upon instruction submits that the Lord Judge Family Court accounts.
Yes, Judge Family Court Katak.
Judge Family Court Katak
Deferring the case
has been deferring the case, that is CP number 288 of 2017 on each date. Para. Stop. Para. Accordingly, it is directed that if the Lord Judge Family Court Katak shall adjourn the matter to a date beyond, with date beyond 20/4/2026, as would be convenient to the learned court in season of the matter. Stop. No, comma, upon a prayer being made for the said purpose. Stop. Eta কাটিয়ে দিন upon prayer being made for the said purpose. Eta কাটিয়ে দিন. The matter shall be listed in the week commencing 13/4. এটাকে অর্ডার শিটটাকে ঠিক করিবে স্ক্যান করিবে
କନେକ୍ଟେଡ୍ କେସ୍ଟା ସେମିତି ଆସିବ
ଆପଣଙ୍କ ପାଖରେ କପି ନାହିଁ ଅର୍ଡର କପି
ନାଇଁ ମୋ ପାଖରେ
ତାହେଲେ
ଥିବ।
ଆପଣ ଯଦି ଚାହିଁବେ ଦେଖିପାରିବେ
ଆଜ୍ଞା।
ତାହେଲେ ଦେଖେଇ ଦିଅନ୍ତୁ
ନାଇଁ
ତାପରେ ଲେଖନ୍ତୁ WPC 18941 of 2019 18941 ଟା କୁଆଡେ ଗଲା ସେ ଫାଇଲଟା ସେଟା ବି ନାହିଁ ନା ଏଠି
ଆଜ୍ଞା ସେ ସ୍କାନିଂ
WPC 18 ଆପଣ ଆଜି କଣ ସବୁ ଚିପ୍ କୋଡ୍ ପଠେଇଦେଲେ ନା କଣ ଫାଇଲ କୁଆଡେ ଗଲା ସବୁ ସ୍କାନ କେମିତି ହେଲାଣି 1 ନମ୍ବର ଆଇଟମ ସ୍କାନ ହବ ସେ ଅର୍ଡରଟା କେତେ 7/3 ଅର୍ଡରଟା 18941 ଅର୍ଡରଟା କେତେ 7/3 order dated 7/3/2026 the matter was directed to be listed along with WPC number 6203 of 2025 stuff none had appeared on 7/3/2026 for the petitioner stuff para today none appears for the petitioner when the matter is called. The petitioner is also absent on repeated calls. I don't think petitioner is present. I am dictating without, it is presumed that on repeated calls he is absent. Petitioner is absent on repeated calls. To grant further opportunity to the petitioner, the matter shall be listed in the week commencing. 13/4/2026. For the opening line लिखिदेबे the matter has been listed both the cases under the heading mediation for necessity. Registry shall intimate the order, today's order, as well as the next date of listing to the learned counsel appearing for the petitioner.
item 2
Item 2, Your Lordship, I have been instructed that the matter may come at the regular bench, Your Lordship.
It will not suffice if it will go to the conciliation process because we can't, because we have the Union of India is the appellant in this case.
Correct, sir. So, in matters where state or union is appearing, I am just adjourning to enable you to obtain instruction.
Yes.
Whether you can go for mediation.
What I am praying, my Lordship, fix for hearing.
No, hearing fix kare to mediation haboni.
Notice টা issue is
ଆପଣଙ୍କର ଯଦି ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି mediation ହବ କି ନାହିଁ ସେଟା ଆପଣ ଚାନ୍ସ ନେବା ପାଇଁ ସେଟା ଆପଣଙ୍କୁ adjournment ଦିଆ
ଠିକ ଅଛି
ଆପଣ ନିଅନ୍ତୁ.
Yes.
Because this is a policy. This is a
Yes, I know the Supreme Court has a
yes. This is a policy of the court and the apex court. And
Yes,
we must wholeheartedly support this.
yes.
Because land acquisition is the fittest case where mediation will work out. If amount is the controversy.
Only problem is that none of the officials is coming with a transparency.
You are absolutely right. Same happens with state. Why? Unless there is a then Mr. Padi, you can use your good offices to have a policy where you can enter into mediation.
Yes, that should be.
Like in income tax appeals, a pecuniary limit has been fixed that up to this limit, no appeal.
Yes.
That is actually, it's kind of a middle path. May not be exactly mediation, but as a matter of policy, you are not, going further in appeal. That reduces the litigation burden. So similarly, in some cases, if you can initiate that at your behest, you can do it.
Yes.
I don't know, whatever will be the result, but it is worth trying that you make a policy that this will not challenge. And it is a beneficiary, he is a citizen. He is your citizen only.
Yes.
Valuation is 1,79,000. Can
I have already said that whether they will have 1,75,000 a citizen is entitled or not, they will go to appeal.
Management take instruction.
So that I am persuading, I mean, explaining Mr. Padhi that he will use his good officers. Mr. P.K. Padhi, Senior Advocate, Solicitor, DSGI, along with
Milan Kumar, Your Lordship.
Milan Kumar,
CGC, Your Lordship.
Mr. Milan Kumar, CGC for the appellant. Mr. M.K. Ponda for the opposite party.
One minute. Government is OP2.
Acha. Tarun Kumar Raut. Tarun is you.
Private opportunity. I'm a private for private, all private opportunity.
Yes. I'm dictating. So M.K. Ponda for OP1, Mr. D.N. Lenka, AG.
P3.
Prabhu Prasanna Behra.
Mr. Prabhu Prasanna Behra, Additional Standing Counsel for OP3.
3.
The matter has been listed under the heading Tiju for referral to the special mediation staff. The Lord Counsel for the respondent number 1 submits that the matter, the amount being rupees 1,75,000.
1,79,780.
Lakhe 75,780.
Yes, sir.
Lakhe 75,780.
79.
1,79,780, Your Lordship.
1,08,000 maybe.
No, simply clear.
1,79,000.
178, tapare kete 79, tapare kete
780.
780. 1,79,780. The matter should be settled by mediation. Para. It is submitted by the, at a hybrid mode, it is submitted by the DSGI that it would be difficult without there being a general policy guideline. And the matter may be the matter may be considered by considered in regular hearing. Stop. In considered view of this court, the learned DSGI can obtain instruction regarding policy of the Government of India, or Union of India,
Yes,
Union of India, whether to pursue such appeal where the Union is the appellate, the amount of rupees so and so, where the Union is the appellant, tapar likhive, the amount being rather small. Yes.
Other than the second matter, the amount is 10,83,600.
Both matter listed matter.
Both matter listed.
Tale process last line ta kati diyo.
Amount ta cut.
Amount ta kati diyo. List in the week commencing and list under the same heading in the week commencing.
Your Lordship, I only pray that there is another matter.
Just one second. Date ta se confuse hojiye phir. Week commencing 13/4/2026.
13 for April.
Second matter that 10 lakh taka avashya. I cannot ask you that apan 10 lakh taka appeal karibeni boli. But apan jodi gote kiछि policy asanta apan he to 10 lakh settle habani. Kintu lakh taka settle he jibo. In fact, I have deleted that line.
That was the discussion in the last meeting of the ministry.
Yes.
But it should be come to a conclusion.
Dekhantu, because maybe they are aware you have.
Yes. Otherwise they can not do it. Come forward and settle the same. Yes.
Yes, you can make aware the Ministry of the Supreme Court initiative. Why the purpose?
Yes.
Suppose 10 lakhs. Suppose I'm giving a hypothetical example. You say 5 lakhs and Mr. Ponda agrees. Then it is a win-win situation for both of you.
Yes.
Correct.
But another two connecting matter is there. Lordship may listed.
I'll give.
Milan Kumar will give the detail.
I'll provide.
And second matter is order hela.
Second matter of state is OP2.
Sabutra OP2. Mr. Bhatti.
First matter is OP3.
Acha. First matter 3, second matter 2. Both Mr.
Behra.
Mr. Prabhu Prasanna Behra. Additional Standing Counsel. First matter ki second matter would add kar diyantu line. It is submitted by the learned CGC that kagaz ta diyantu likhi debe. So that LAA are connected arising out of the same land acquisition proceeding notification.
Yes, sir.
Notification saman
Same.
same notification. It is Accordingly, it is directed the matters shall be listed together along with the present appeal in the week commencing 13/4/2026.
Item 3.
May I please proceed?
Yes.
My lord, here we are challenging the ex parte order dated 27/11/2025 in the CRP case number 165 of 2025, which was passed by the family court judge Baipada. My lord, here they made an order within 2 days and they served a notice to the petitioner in the wrong address, which is not the actual address, my lord. My lord, the actual and the permanent address is in the affidavit. Here they served a notice on which is the petitioner is residing at Kolkata. My lord, here petitioner is not residing at Kolkata. Petitioner is residing at Chakrisari, Bhubaneswar. Here they made a notice, and notice was served to find out the non-appearance from the side of the petitioner, who was the opposite party, and they passed the judgment 144 of BNSS. My lord, we are paying the amount of 13,000 and 10,000 to the OP number 1 and 3,000 to the OP number 2, who is the son of the petitioner.
So, can I, after you complete your submissions, I will start asking. Absolutely dot on the point and relevant questions. You have examined the law on this. Have you read?
Yes, sir.
Which case law?
Yes.
Don't remember the citation. Okay. Because that is more on a personal note. You being a young counsel, always get prepared and always prepare on the points which have already been decided by the Supreme Court against your contention. Always. I mean, as it is said that good lawyers make bad cases, good cases out of nothing. Actually, that statement is not correct. The good lawyers, they know, like Arjuna, that where to hit. So unless you read the case law, you make a speech. It's almost impossible.
Sorry.
I have never, to my little experience, I spent time at the bar for 22 years, more than 22 rather. Never without preparation, if I make a speech, I have never survived. That's the first point. That's on a personal note, not regarding the curve. Now, what you are arguing a revision. So you are finding fault with sufficiency of notice. Correct. So it has to be reflected from the order sheet of the court and the report. Here it is called stamp report. In trial court, Mr. Lenka, it is called office note. Same here, it is also, I use the language office note actually. Office note put up by the registry, I use the right. Here also office note. Stamp report is regarding correct or wrong. So have you examined that? Now I trust you. I like you. I will record verbatim, I will reproduce whatever you have said. I pass a order. Can I do that as a court? You have to show it. You have to some basis of submitting what you are saying. You say that it was decided within 2 days. Notice was not served. And your opening statement is that I challenge the ex parte order. A party is said to be ex parte, especially opposite party. There is a provision in CPC. Otherwise, the court cannot. It's not kind of a panchayat solution. Court is completely bound by. So there has to be an order setting you ex parte. So thereafter, what happened? And now when I ask you this, or suppose you would have continued for another half an hour, I ask you this. You are struggling. My struggle is more because I do not know what order I can pass. If you would have substantiated that by looking at the order that I was set ex parte on this was the office note. And no court in India, I can't tell about other countries, no court of India will not make this fundamental mistake. Possibly it can. We are making. At least I have seen that we are making. You can tell that without verifying the sufficiency of notice, I will proceed. Now, what is the remedy if you are state ex parte, whether you have adopted or not, that is another question. So this is the legal part, CPC procedure, because Family Courts Act is bound by procedure. Next part, suppose you are paying. So if you are paying, then what you have to do? To show to this court, you have to file. It cannot be me liking you and impressed by your submission. So and so submits, he is paying, he is paid. Because you are not the person who is paying. The person who comes to you, to your chamber, and you are arguing on his behalf, he has to file that affidavit. So where is that? Where are what I have been telling you? Where is that? How can I proceed now? You have left the court in the lurch. You look at page 4, running page 15 of your brief, paragraph 3.
Yes, ma'am.
Read that aloud. Otherwise, how I will know what you are reading?
The opposite party filed if the court for which he has not contested the claim of the petitioners, he was set ex parte by this court night order dated 24/9/2025.
Now kindly look at the judgment date. That you find at page 13.
Yes, ma'am. 7/11/2025.
So 24/9/25 and 27/11/2025. Whether you wrongly said 2 months to be 2 days?
Sorry, ma'am, 2 months. Yes. 2 months. 2 months, ma'am.
You have to be careful.
Yes, ma'am.
Never presume that the judge will not read. Even if I read with you.
And I also.
No, not that. So it's a case where after 2 months, the judgment is pronounced, you are set ex parte, what is the proceeding? So wherever you stay, because somebody staying in Kolkata or Chakeshwar in Bhubaneswar, court will not, because you see, suppose there is a provision in CPC that somebody staying in so and so place, or there is any evolution of law by interpretation by the Supreme Court. It's not that. At least make an effort to make the basic presentation correct. Basic presentation, first principles. Yes, what do you want, sir?
Any other treatment?
Your name, sir?
My name is Devasis Ray.
Mr. Devasis Ray for the petitioner. Opposite party blank. The petitioner husband is before this court challenging the judgment dated 27/11/2025 passed by the learned judge, Family Court Baripada, District Mayurbhanj, in CR.P. number 165 of 2025. You take your seat, I'll take some minutes to dictate the order. You can sit down if you like. 2025. The said petition was initiated by the wife in the marriage and the minor girl child. Is it about 3 years? Is it about 3 years? Represented through her mother guardian under section .144 of Bharatiya Nagarika Suraksha Sanhita, 2023, claiming monthly allowance towards maintenance. Stop. The petitioner was favored. The petition was favored, not petitioner. The petition was favored. However, granting monthly maintenance of rupees 10,000 to the minor daughter, to the wife, and 3,000 to the minor girl child, instead of 70,000. And 20,000. Sorry, instead of 70,000 consolidated amount claimed by both mother and child. Litigation expenses claimed at rupees 20,000. दो claimed rupees 20,000, rupees 5,000 was directed. Stop. It is submitted by the learned counsel for the petitioner that notice was not served on the petitioner, who was the opposite party before the learned judge family court. The order has been passed ex parte. Stop. The learned counsel has adjournment to substantiate his submissions by referring to the order sheet, the entire order sheet in the said, in the CP number, CRP number 165 of 2025. Stop. It is submitted by the learned counsel that the petitioner husband, that's father, is paying rupees 13,000 as directed by the court. Stop. The petitioner shall file affidavit indicating the payments made till date. Stop. Para. In view of the judgment rendered by the apex court in Rajneesh versus Neha, the amount awarded as maintenance to wife and child under section 144 of BNSS is akin to a money decree. The petitioner shall also indicate in the affidavit how he will secure the amount as has been directed by the learned judge family court, which is under challenge. Kebe Mr. Ray? Kebe asle hobo?
Any date.
Any date the computer is not taking. Any date, my lord, PGS is not available. It is in numerical 1 to 30 or 31. Okay?
Second week of April.
Second week of April. List in the week commencing 13/4/2026. And never feel defeated in arguing matter. You are doing your job. So whenever the court is discussing with you, only to encourage you, so that you sharpen your skills. And as a student of law, still I believe I am learning every day. That should be the spirit. Yes, next.
Item 4.
Mr. Pujari. Mr. Vasudev Pujari for the petitioner, opposite party black.
Sir, may kindly turn to page 8. Page 8 of my brief.
Yes, please.
The prayer is, we are seeking transfer of CMA number so and so, arising out of CP number 553 of 23 in the court of the Judge Family Court, Raukala, Sundargarh, to Raukala, Sundargarh from Cuttack.
Yes.
Last time your lordship had put a suggestion or rather a question to me as to whether it would be advisable to get it transferred before that CMA is disposed of.
Because the restoration is because it should be so. What is the law on this?
It is simple. My prayer would be, your lordship may direct that the CMA be disposed of within a particular period. Thereafter, I can renew the prayer.
No, of course. The prayer for transfer you need not renew. It's every time. It's not a res judicata concept.
Yes.
It can be any day.
No, unless that
But the direction to fixed timeline is not possible.
any date, any.
No, expedition as yes,
So that I can move.
because after the Constitution bench judgment, language used by the Constitution bench judgment,
I agree.
Asian that
Yes.
where Supreme Court had directed
Asian resurfacing
that 6 months vacation. Then they constituted Constitution bench. They recalled that order or modified order.
Yes.
And also noted in para 43 that no constitutional court should direct fixing timeline, but as expeditiously as possible. Okay, that order I will pass. Can you take your seat? I'll take some time in dignity. Mr. Basudev, opposite party black, order number 1, Juda Achi, Sithre. Para 1 to repeat hala. But the matter was had at some length on 2/2/2024. And after the deliberations in the court, the following order was passed. Para 2 ta quote kar dene. Para 2 of order number 1. Today, when the matter is taken up, it is submitted by the learned counsel for the petitioner that at this stage, this court need not go into the question as was discussed and noted above in paragraph 2 of order dated 2/2/2026. आपनकर restoration टा pending अछि ना allow है
Pending अछि.
It is submitted that the learned judge family court say uchanti learned judge family court Cuttack, learned family court Cuttack may consider the CME and dispose it of as expeditiously as possible. Para. In view of the aforesaid submissions, it is the petitions is disposed of. Observing that the learned judge family court shall dispose of the CMA number 60 of 2025 as expeditiously as possible. That would be possible as expeditiously as possible. That may happen as per the number of cases of the pending before the learned court. Para. The learned court shall consider the fact that आपनकर जोटा initial CP टा केबे फाइल हेतला
CP टा 5/43/23
may consider the fact that the CP was filed in the year 2023 indicating cause of action arising in the year
23 itself.
2023. So
Marriage was 2019.
23 था
Again.
2023. The petition is disposed of.
Madam Bhai,
Mr. Bijay Kumar Misra for the petitioner, opposite party blank. Yes, please.
The petitioner filed this is a petition for seeking a transfer of divorce proceeding from the pending before the Civil Judge Senior Division Banquet to Bhubaneswar, Family Court, Bhubaneswar. The petition, the opposite party, the husband, filed a divorce proceeding before the Civil Judge Senior Division Banquet. So that can be transferred to the court or to the court of learned judge, Family Court, Bhubaneswar.
Grounds, which provision is there in CPC for transferring?
Section 24.
So kindly read section 24.
Is Lordship, I mean, excused Lordship that.
No difficulty, sir. I am providing books to everyone, sir. Why I should don't feel diffident? मुझे देखो तो language देखो तो ये छोटे से language
General power of the transfer on the witness.
Kindly read the language, sir.
So on the application of any of the parties and after notice to the parties and after
No, you just read further because there is lot of time. It says convenience of the parties.
on the
But-
application of any of the parties.
In the parties, but the last part is the convenience of the parties.
Mm.
It is not convenience of any of the parties or one party.
Your Lords.
How many cases he has filed against the husband?
No, I have only one the GR case is pending before the JMX one Bhubaneswar. That is one. No other kind.
So then what is the logic? Then read section 9.
Your Lords, another
Section 9 देखो तो ठीक.
another
Sir, our job is, your and my job is to talk,
Your Lords.
speak, discuss law.
Your Lordship, section 9
Kindly read.
votes to try to civil suits unless bad. Votes to try all civil suits. Section 9 of
So what is the stage of litigation there?
stage of litigation, Your Lordship, I could not receive the notice because the door, because most of the time I remain absent. So door is locked. Therefore, they set expiry and I have filed a petition for setting.
Order 9 rule 13.
Order 9 rule 7. 13 is expected decree. So
7?
decree has not been filed.
7 you are challenging the order setting you expertise.
Setting expiry.
Okay, order 9 rule 7.
Order 9 rule 7.
So now then nothing is in your favor. Just now you have heard Mr. Pujari.
Your Lordship. Only
So now transferring a petition.
Mine is ground, I have only 2 to 3 grounds because only 1.5 year child is with me. Because
Suppose it is at Bhubaneswar.
Your Lordship.
The child will be carried to court.
Most of the child, but it will
Never.
it will take 1 hour.
You must understand. You must understand that I have to dictate that order.
Yes, Your Lordship.
If I state that precedence that whoever is having a child, the matter should be at the nearest place or the court has to come to. That's not the concept. You have to, like you have filed an FIR in Bhubaneswar.
Yes, Your Lordship.
So you will be the principal witness. You will carry the child to court.
No.
So you have to. The logic is. I mean the way is you have to leave the child in care and custody of somebody.
But it will.
So 1.5 year child, how does it help you? You must understand in your cause of seeking transfer to Bhubaneswar, like you have filed an FIR 498A.
Up to 98.
So how does it help? 1.5 year old child, how will attend the court in Bhubaneswar?
If it is Bhubaneswar, it will take minimum time. So that if I will
How can it
the
be?
court
How can it be?
at Banki.
I mean, is it that have you ever practiced in Bhubaneswar? Banki is a possibility that the court will take up your matter. But Bhubaneswar, you have to wait till 2:33 post lunch. And which is the provision that deals with the women with a child will be allowed to have the court, because section 9 is clear, 24 is clear. 24 is clear also. That convenience of the parties. You are saying that convenience of one of the parties.
No,
And then after you have filed order 9 rule 7 application,
yes, sir.
how another court will consider that?
Order that may be said expert after taking evidence, because the court will take evidence.
No, you are not advising me. You answered the question. I am not seeking any advice. The court which has set you expertise and you are setting aside recalling of that order, how the other court will take up that?
But there is no bar if it is transferred.
No, that's a question to you. You have to answer that. That every time a person is set expertise, the matter will be transferred and it will be considered by another court.
For convenience or better adjudication, you lots.
No, ଆପଣ ସେଟାକୁ answer ଦିଅନ୍ତୁ convenience section 24 ଆପଣ କହିସାରିଲେଣି. Section 24 ଆପଣ କହିସାରିଲେଣି. So ସେଟା ଆପଣଙ୍କ answer ନାହିଁ that convenience of one of the parties. ଆପଣ ଦେଖନ୍ତୁ one of the parties ଲେଖାହେଇନି.
My submission equal also may direct that after setting aside that expertise order, so that may be.
No, I am not taking dictation from any particular client. You may take. How can that biased I cannot be? That since so and so has Goodly Mishra has come to this court, you decide her case and set aside the expertise order. You have to move the court to pass that order.
No, you may actually
You may succeed and you may fail.
Oh, your lordship.
So that you will challenge. Suppose now the order passing directing you set 9 order 9 rule 7 is
May
rejected.
be disposed of. Even if it goes against me, that challenge will.
So then if it goes against you, you will challenge and I will direct transfer.
No.
Sir, this is not no merit in the case. No merit in the case. And engaging a lawyer at Bhubaneswar is same as engaging a lawyer at Banki. One thing, if you do not want, you can use through VC or ICT modes, but at your choice. So that provision is not there in Family Courts Act, Section 19, Hindu Marriage Act, Section 9 of CPC, Section 24. Nowhere it is there. It has been judicially involved. And here is a star case where the person, after being set ex parte, wants transfer of the matter. No merit.
If your lordship it is transferred here, also by taking evidence, this court also, the transfer court also can take evidence.
So that's not a matter of speech. You are interpreting law as if you are. I can't interpret like I am Dimso Mullah or you are SC Sarkar. So some precedence. Is there? I don't have any with me. You have to educate me.
Exactly.
After the court has said, because at least after to be precise, almost 1.5 months, Mr. Pujari has realized that. In fact, I sought his assistance.
Yes.
In fact, I am seeking your assistance. Then what is the law on this? Because then Order 9 Rule 13, in his case, it is Order 9 Rule 13. So after the Order 9 Rule 13 is filed, transfer. Then the problem is then look at Order 9 Rule 13, Order 9 Rule 7. ଆପଣ ଯାହା ଏଣ୍ଟାୟାର CPC ପଢଉଛନ୍ତି କିନ୍ତୁ ବହି ଆଣିନାହାନ୍ତି। ମୁଁ ନିଜେ ବି ପଢିବା କଥା। Order 9 Rule 7 ଦେଖିଲେ?
Order 9 Rule 7.
अरे कौन पाउल हैं तो?
Procedure where defendant appears on their
Where? Procedure where? Slowly पढ़ो तू। Authority to the
where the court has adjourned the hearing of the ex parte of the suit ex parte and the defendant.
Can you stop there? अपन पे first line is most important. तापर पढ़िया भी दरकार नहीं।
Where the court
has adjourned the hearing. Which court?
The
Transferee court.
No.
This was the question to. Now the question is to you, as was asked to Mr. Pujari. Transferee court. It is the court.
The court. Which has
yes, it is the court. It is not. So now that is how I was seeking your assistance, whether it can be considered, obviously it is not by post, not the person, but court. So every time Order 9 Rule 7 is, when a petition is filed, suppose it is transferred, then kindly read further, where the court has adjourned the hearing for suit ex parte, and the defendant at or before such hearing
appears and ascends good cause for his previous non-appearance.
So that is important.
He may upon such terms as the court directs.
Which court? Transferee court? High Court?
No.
Now you said that direct
the court which has passed.
So what is the meaning of the court?
The court which has passed the order.
Correct. Order 9 Rule 13, Order 9 Rule 7, that is my limited understanding. So you are making a most difficult proposition without any supporting case law. Now same thing in a first appeal. In a first appeal, High Court passes a order, ex parte, Order 9 Rule 7 is filed, Supreme Court will transfer. Now, because technically possible, in a first appeal, the party staying in Delhi or party staying in another state files a appeal SLP before Supreme Court. Let it be transferred at Order 9 Rule 7 stage. Even these are Supreme Court rules are very similar to CPC. I mean, you are too senior in the profession.
Let it be disposed of so that.
So that is now prohibited by Supreme Court Constitution bench decision. The language used is very.
The code means which code the court has passed the order.
So you move it. Move it. As same order as expeditiously as possible for the. But my concern is that is completely contrary to the Supreme Court decisions. I have to repair the order accordingly.
Yes,
But as if I am not directing. In the subsequent order, in case of a trial, delay in a criminal trial, Justice Oak's judgment is the High Court is doing every day which it should not do. The reason being, there are so many Order 9, Rule 7, so many CPs pending before Banki Court. Why the High Court will pick up one case, which I just asked you? Because that is as if I have picked up one case where, the petitioner or maybe the lawyer, if no other case is pending, no other matter is there, then it's a different thing. That the Supreme Court has highlighted. And in the supplementing judgment, Justice Mittal has written one word, one paragraph. He writes the opening statement. In the pursuit of doing justice, we do injustice. This will be a classic case, what I will be doing by picking up your case, dispose it of. And Mr. Arya's case, languishes. Mr. Abhayas Mishra's case, because they did not come to court at the stage of Order 9, Rule 7. But since there was no time, I didn't engage Mr. Pujari whether he has examined this aspect. Order 9, Rule 7, Order 9, Rule 13, D court can be the transfer report also. But anyway, so since again no opportunity of answering that. Someday there will be some pronouncement. I think the reasonable interpretation is it has to be that court. Because then it becomes
he has passed the order.
Mr. Mishra, then it becomes a hide and seek. Today, this court, here suppose, I pass a Order 9 ex parte. Then you file it another court. Then another court. So, because that's a logical consequence of this.
ସେଇଟା dispose of ହେଲା ପରେ ଯାଇ transfer
ଆପଣ ଯାହା କରିବେ ଟ୍ରାନ୍ସଫର ଆପଣ ଯେତେବେଳେ ସିକ୍ କରିପାରିବେ 24 ବଟ୍ 24 ପ୍ରୋବ୍ଲେମ ଅଛି ସେଟା ଆଉ ଗୋଟେ ବଡ ଜିନିଷ କନଭିନିଏନ୍ସ ଅଫ ୱାନ୍ ଅଫ ଦ ପାର୍ଟିସ୍ ଲାଙ୍ଗୁଏଜ ଇଜ ନଟ୍ ଆଟ୍ ଅଲ୍ ଦେୟାର ଆପଣଙ୍କ ଆର୍ଗୁମେଣ୍ଟ ହେଲା କନଭିନିଏନ୍ସ ଅଫ ୱାନ୍ ଅଫ ଦ ପାର୍ଟିସ୍ ସେ କହୁଛନ୍ତି ଆପଣ ସେଟା ଦେଖିବା କଥା ୟୁ शुड बी सीरियस स्टूडेंट ऑफ लॉ इट सेज petition by either of the parties.
Either of the parties.
But the consideration is convenience of both the parties. That is very interesting.
Most of the judgments, most of our High Courts, also Supreme Courts, most of the judgment is convenience of the
not a single judgment. Not a single judgment has given reason. Two of our High Court judgment I have because I will be happy to learn from you. Simply one, go to sweeping line DH. The convenience of the wife should be looked into. That much. Nothing. 24 refer any. Section 9 refer any. Section 19 be refer any. So sweeping judgment kale, that's a different thing. Kari habo because High Court has the liberty to make sweeping judgments also, but it creates a precedence.
What is it a judgment?
In fact, jone mane apanko colleague jone je pacharli se kala mu dekhini mu eta ku lekhi dechi. But tapare mu sera bahar kale se judgment guda say one line अपन जोड़ा
हां मु देखि से जजमेंट
किछि लेखा नै
से जजमेंट आउ थरे पढी के आसीबा पे कहसन कि जजमेंट
से न किछि लेखा नै
प्रिपेयर हे के आसीबा
से किछि लेखा नै दे
टीआरपीसी 1 आई थिंक
सेतरे लिखा त नै जा जदी सेतरे टिके भी देखि थांते सेक्शन माने सेक्शन 9 सीपीसी सेक्शन 24 सीपीसी read with 19 and other and that is one of the reasons where Supreme Court in many cases is directing VC kana interstate he जाउची जड़े रहउचंदी कन्याकुमारी रे काश्मीर रे रहउचंदी हस्बैंड से कन्याकुमारी थे कहउचंदी आया मोर केस आसु कन्याकुमारी सुप्रीम कोर्ट हैज नॉट ग्रांटेड दैट रिलीफ आपन आर्गुमेंट एक्सेप्ट करले
बट आई फील दैट इन मोस्ट एक्चुअली फैमिली कोर्ट केसेस रे इट्स अ कंसिलेशन 2 to 3 times conciliation will be held. Physical presence of the parties most of the time required. At least in family court.
So now if then it has to be amended. Section 19, Section 9 and 24 have to be amended. और जेतबेले लॉ ए पर्यंत गोटे भी प्रेसिडेंस नाही जोतरे कि कहिछि जे व्हाटएवर मे बी द स्टैट्यूट कोर्ट्स परसेप्शन
yes sir
court's perception and there is a strong perception that many a time the husband is unnecessarily
Being harassed.
Not harassed. Sir, he enters into endless process of litigation. Upon the case करें देवेनी, conciliation करें देवेनी. Conciliation is statutory. Upon the frustrate करें देले. Even upon this has gone to this extent that where the husband files the case in wife's place. See college mu Hon'Ble MBA पढ़ी मते Hon'Ble case transfer करूँ. It is argued 2-3 days back. सेटा भी आर्गुमेंट होची तो आपण तार आंसर द रीजन बिंग आपण जेतु गोटे लाइन लिखि देले कन्वीनियंस ऑफ द वाइफ सेटा कोर्ट आरंभ कोर्ट शेष तो तार किछ लिखिले ना दैट्स द प्रॉब्लम
Each case has to be taken.
देयर इज नो सच ये आपण को हार्ड केस थाई पारे देयर आर डिफिकल्टीज और जिस लिखियो से तो आईसीटी पैराग्राफ इफ दे वांट दे कैन इफ इट इज परमिसिबल अंडर लॉ आपण को काउंसलिंग फिजिकल नॉल हे परिबनी आपण भुवनेश्वर काउंसलिंग जेति केस रही जेति काउंसलर अच्छा पॉसिबल नुह करवा आपण बांकी कटक भद्रक बारिपदार सब भुवनेश्वर करेंगे तर आउट भी रीजन अच्छे भुवनेश्वर देयर आर लॉट ऑफ मैरेजेस हैपनिंग इन भुवनेश्वर होटल्स मैरेज मंडप्स villages are not the preferred choice for marriages there can be so many reasons also
yes. Permanent resident of Bhubaneswar
whatever yes yes please next Mr. Deepak Ranjan Parda for the
Item 6.
petitioner
If the petitioner is
Mr. opposite party black yes please
petitioner wife and husband is the opposite party. Opposite party has filed Section 9 of Hindu Marriage Act, institution of conjugal rights. File it for the Jastur, family court Jastur. There was pending before this dispute family court, and the date was fixed to for appearance of the wife 11th of this March. In that matter, the petitioner wife
125 ago 9 file is na ago 125 file is
so in the year of my lord, he has filed 26 of 26 the 125 I have filed before the Kendrapada court, my lord, just family court, where I am residing in 2
apana after the wife has received notice in the section 9 she has filed 125
No, that is not.
So what is the date? So Parda, you should have asked these questions. I am not to assist everyone. Apan ko assist kale kemte ho? You are sufficiently now spend your time. Because the usual argument is after I have filed 125, he has filed section 9. So for that only I am asking you. Is it your argument that after you have filed 125, he has filed section 9? No, that is not the argument.
That's not the argument, but said both the cases are filed in the 2000 notices. Yes, my lord.
The notice diyantu.
And so for the my lord. If I also
just now I was discussing with Mr. Misra. Upon the section 9 bhi kare debeni. So and whereas there is no provision in law that the husband file kari paribeni section 9. जहाँ भी अपन पढ़िबे and section 24 is very interesting language. Convenience of the parties अपन करिबे.
Opposite party husband also residing in service place in Bangalore.
से कौन करिबे आज्ञा?
Yes,
अपन तो केस करे देबेनी
file the Jastur.
Conciliation करे देबेनी, section 9 करे देबेनी. Kana it has to be only for the interest of the look into the convenience of the wife. कोर्ट से आसिला से concept टा को section रे अच्छी even Supreme Court judgment रे भी नहीं.
Law is
Supreme Court is discussing. Rather, Supreme Court is now directing that you appear through VC and wherever it is there, it is there. Notice Nyon?
Yes. I also.
That is the purpose. Section 9 upon kore debeni. Restitution kore debeni. About 127 maintenance. For a section 24 file, jodi allow interim maintenance ki 125 re. CP class in पढ़ी रहा most of the lawyers का argument है I am going on paying maintenance the CP में adjourn नॉलेज CP का transfer petition file की stall है वाला तभी होच
transfer
that is reality that is reality
दीटा के सुनानी होगा उस जगह के अंदर
किन थी पर है 125 magistrate
that is also
और no my lord है Rodriguez versus नेहा को अपन लोग अच्छी BL versus magistrate और civil most places family judge is the senior most judge प्रिंसिपल डिस्ट्रिक्ट जज माने जो रैंक माने एठी तो प्रिंसिपल डिस्ट्रिक्ट जज नाहंती माने डिस्ट्रिक्ट जज ही होचोनी फैमिली जज डीवी और जदि गोटे जगह अच्छी हम ना आपनकर जोटी जा करेंगे फैमिली कोर्ट तार केस अभाव अच्छी जोटी मल्टीपल केसेस आर देयर टू अवॉइड मल्टीप्लिसिटी एंड ओवरलैपिंग jurisdiction दैट इज द पर्पस कह सी 24 देला बेलू 125 देखा पड़ो कि 25 धरतु से अवार्ड कले ना डीवी 125 इज बिफोर द मैजिस्ट्रेट नॉट बिफोर द सिविल डिस्ट्रिक्ट जज. Yes, you take your seat. I'll get the order. Mr. Deepak Ranjan Polda for the petitioner. The petitioner wife in the marriage is before this court seeking transfer of the CP number 34 of 2026 pending before the learned judge, family court, Jajpur. The said the CP has been filed by the husband in the marriage under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. Notices were issued by the learned judge, family court. Let's go. On 9th February 2026, fixing the date, 7th February, 7/2, by notices were issued by order dated 7/2 February, 7/2/2026, fixing the date of appearance to be 11/3/2026. Stop. It is submitted that the petitioner is in distress. Se batan koti rahuchoti agya.
Not staying with other's house, Kendrapada.
After her marriage has run after her marital relationships have turned into difficulty, she stays with her parents at Kendrapada. तापर MBA करिवे or what 124 because it is very innovative. When arguments actually, if you think actually, it's good. MBA MCA भी कले हम तापर लंदन गले कौन हो सेटा से आंसर दे पले राज्य नहीं गला मैटर कौन लिखले Kendrapada. It's further submitted that the petitioner wife has filed application under the provisions of the 144 BNSS, now 125. The section 125 of the CRPC. এটা কেমতি 2026 মସିହାରେ ବି କେମତି କରିଦେଲେ CRPC କୋଟ କରିଦେଲେ under section 125 CRPC seeking monthly maintenance from her husband in the marriage. Which is pending adjudication before the learned judge, family court, Kendrapada. Top para. Issue notice along with this order. Top para. Requisites for issuance of notice be filed by speed post with registration and proof of delivery. Stop. Sub para. Requisites for issuance of notice be filed within 5 or 7. Lordship. Within 7 working days. List after yes, sir. Devoted to mention. तो लिखले नोटिस इशू कले रिटर्नेबल डेट आज होची केते 20 तारिख 20 हेले रिटर्नेबल डेट बी फिक्स टू 17/4/2026 लिस्ट इन द वीक कमेंसिंग 27/4/2026 27/4 हेले 4 12 आइए IA 75 of 2026, the IA has been filed by the petitioner seeking stay of further proceeding in CP number 34 of 2026, pending before the Learned Judge Family Court, Jajpur. Stop. Had learned counsel for the petitioner, he reiterates his submissions as noted above. Stop. Issue notice as above. Accept one set of process fee as well as postal requisites along with the petition. The returnable date and date of listing shall be same as above. Stop. Same thing only as directed above. That's directed above. Stop. In the interim, it is directed that keep a date janchandi. CPDA ko jano posting each.
11 पर है मौजा.
Achha.
I'm not taking it.
In the interim, it is directed that the Learned Judge Family Court, Jajpur, na?
Yes.
Jajpur shall adjourn CP number 80 to a date beyond 4/5/2026 as would be convenient to the learned court in season of the matter, stop, comma, upon a prayer being made for the said purpose. Stop. Liberty to mention. Yes.
7.
Urgent certified copy as per each copy.
Pray for an adjournment, Your Lordship. In Your Lordship, one more.
Our copy serve करना है? Yes.
Yes,
Copy भी dole. Your name, sir?
Sumanta Bhuiya, Your Lordship.
Mr. Sumanta Bhuiya for the petitioner. Mr. D.N. Lenka, AGA for the opposite party. Opposite parties, plural. The learned counsel for the petitioner seeks and has adjournment. The matter shall be listed in the week commencing. For fresh admission in the week commencing 13/4. 13/4.
Yes.
13/4/2026. Regarding the office note indicating that copy of the writ petition has not been served. The said note shall be treated to be complied with as copy of the writ application has already been served on the learned AG. Mr. Das, your matter.
Your Lordship, one more prayer.
Yes, please.
Your Lordship, this matter may be listed with the WPC number 479 of 2026, Your Lordship, since both the matter are same, Your Lordship.
সেটারে কিছু হেইছি অর্ডার হেইছি না নাই?
No, Your Lordship.
তো সেটা আসু আগ সেটা হেলা বেলে কহিবে। और বুঝছেন কাট বিফোর দ হর্স হর্স বিফোর দ কাট।
No, Your Lordship.
ଆପଣ ଯୋଉଟା ଆର୍ଜନ କରୁଛନ୍ତି ସେଥିରେ ନୋଟିସ ହେଇଛି କି ହିୟରିଂ ହେଇଛି। ଯଦି ସେଟାରେ କିଛି ହବ ତାହେଲେ ଏଟା କହିବେ ତା ସାଙ୍ଗରେ ଟ୍ୟାଗ ହବ। ସେଟା ଆଗ ଆସୁ ବୋର୍ଡ କୁ ଆସୁ। That matter is not on board, that is out of the board.
Yes, sir.
That is yet to be listed. If it is listed and it is to be heard, you never know. যদি same matter টা dismiss ହେଇଗଲା ଆପଣଙ୍କର କଣ ଲାଭ ହବ ତାହେଲେ? ବୁଝିପାରୁଛନ୍ତି ଏଥିରେ ଇଣ୍ଡକ୍ସନ ହୁଏନି। ବର୍ତ୍ତମାନ ଗ୍ୟାସ ର ସର୍ଟେଜ ରେ ଇଣ୍ଡକ୍ସନ କୁକିଂ ବହୁତ ହଉଛି। ତେଣୁ ଆପଣଙ୍କ ରିଟ୍ ରେ କଣ ଇଣ୍ଡକ୍ଟିଭ ରିଟ୍ ହେଇପାରିବ? ସେଥିରେ ମାନ୍ଦାମସ ଇସ୍ୟୁ ହେଲା ଏଥିରେ ବି ହେଇଯିବ। ସାଇଡ ବାଇ ସାଇଡ ଦିଟା ଫାଇଲ ରହିଲା।
Pardon, Your Lordship. Now I remember, Your Lordship, on the last date, Your Lordship, this has been served.
କୋଉଥିରେ?
On 479 of 2026.
ଆରଟାରେ ତ?
Yes, sir.
ଆସୁ ତାହେଲେ ସେଟା। ତାକୁ ଆ ପାଇଁ ତାକୁ କାଇଁ ଖରାପ କରୁଛନ୍ତି?
In this case, I am petitioner. On that case, I am the.
ସେଟା ଆସୁ let it come.
Yes, sir.
ଆପଣ ଏଇଟା ଆର୍ଜନମେଣ୍ଟ ନେଲେ you have a clear strategy in your mind.
Yes, sir.
ଆପଣ ଯୋଉ the way the cricket is being played dictionary, it is unthinkable. 147 is hitting a 6. One of our batters, an English bowler, he hit him a 6 in he's bowling 147.50. When I used to play 40 years back, 80 रे मते देखा जाउ नथला. We had a bowler 1 year younger to me in school. I could not see what he was bowling. It is a mind. My point is, I draw a lot of inspiration from this correlation with cricket. ଆପଣ ଯଦି 5ଟା ଇନିଂସ ଖେଳିବେ ତାହେଲେ ହିଁ ସେଞ୍ଚୁରୀ ହବ। ଆପଣ ପ୍ରଥମରୁ ଇଏ କରିବେ। So be patient. ଆପଣ ତ କେସ୍ ଆପଣଙ୍କ ହାତରେ ଅଛି କାହିଁ ଛାନିଆ କରିକି ତାକୁ ଇଏ କରୁଛନ୍ତି। କେମିଷ୍ଟ୍ରି ଆପଣ ଫିଜିକ୍ସ କେମିଷ୍ଟ୍ରି ହେଇଥିଲେ ମାନେ ଇଣ୍ଡକ୍ସନ ଯେ କୋଉଠି ଆପଣ MRI ଠୁ ନେଇକି ଘରେ ରୋଷେଇ ଘରେ ବି ପହଞ୍ଚିଲାଣି ସୋ ସମ୍ ମାନେ ପାଥ ବ୍ରେକିଂ ରିସର୍ଚ୍ଚ ହାଜ ହେଲ୍ପଡ ଅସ୍ and this is all by humans. We are really, I mean, God's creation, what a special creation. कौन हमें नौकरी पर? Yes, of course. The sad part is that we are fighting and that
butter.
The petitioner challenged the order dated 1/9/2025 matter. Wherein the non-justice family judge has commented against the petitioner, the wife in the court below matter respondent that
comment call এটা ফেরে কোন এটা কোন jurisdiction sir
matter
কো comment কোন হলা sir
ये देखो
কোন order sir
1/9
আচ্ছা 1/9 order আচ্ছা ঠিক আছে yes
both parties are present amicus curiae for the petitioner is present and filed hajra and an advocate for the respondent filed a petition praying for time on the ground that therein consideration report he received the conciliator stated therein that the matter is referred due to non-cooperation of the both parties are present. Even if the petitioner is present, I myself is found up, then sort of will stand against me. But and the when I was present, my
sir, just kindly listen to me, sir. Sir, this is regarding conciliation, not regarding appearance. If I have understood you correctly,
my submission was that the letter is chance to be given to the respondent for conciliation. बिल्कुल दिया ही नहीं और सांगे हियरिंग उसकी इट इज व्हाई अप्रोच दिस लोग को
ना कॉन्सिडरेशन रिकॉर्ड देखियो पड़ियो
टिपर लिखा
से सुनो
सर इसे
रिपोर्ट काइन रिपोर्ट ही नहीं आतिरे ଆପଣ ନିଜେ ଦେଖିଛନ୍ତି କି ରିପୋର୍ଟ
ଜମା ହେଇନି ସାର୍ ରେକର୍ଡ ଆଇ ହାଭ୍ ଗନ୍ ଥ୍ରୁ ଦି ରେକର୍ଡ ସାର୍ ଜମା କନସିଡରେସନ ହେଇନି
ସେମିତି ହବନି ଆଜ୍ଞା very rarely you will find agically family judge everywhere are senior most
I am not paying this to take adjournment. I am on the point. Let is chance be given.
ଆପଣ ସାର୍ ସାର୍ଟିଫାଇଡ୍ କପି କନସିଡରେସନ ରିପୋର୍ଟ ଆଣିକି ତ ଫାଇଲ କରିଥାନ୍ତେ ଯଦି କହୁଛନ୍ତି ଯାହା ବି ଯଦି ଆପଣ ଇଏ ସାର୍ ଦିସ୍ ଇଜ ନଥିଙ୍ଗ ସାର୍ ଆପଣ କାହିଁ ତାକୁ ଛାଡି ଦିଅନ୍ତି କେସ୍ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯାଉ ସାର୍
ନାଇଁ ସାର୍ ଏଟା adjourn ହେଇଯିବ ମୁଁ ସାର୍ଟିଫାଇଡ୍ କରି ଆଣି ଦେଖୁଛି
କନସିଲେସନରେ ଆଜ୍ଞା ବହୁତ କଷ୍ଟ ମୁଁ ତ ଏଠି ଆଜ୍ଞା ଚେଷ୍ଟା କରିକି ଡିଭିଜନ ସିଙ୍ଗଲ କନସିଲେସନ ଇଜ ଇମ୍ପସିବଲ ସାର୍
ଗୋଟେ ଦିନ ତ ଦିନ ସାର୍ ନହେଲେ ନାହିଁ ଗୋଟେ ଦିନ ତ ଟାଇମ ନେବିନି ଆପଣ ଏମିତି ଆର ପଇସା କଲେ ସେ 20 ତାରିଖ ଦେବୁ କି
ସେଟା ଆପଣ ଯଦି କହୁଛନ୍ତି କନସିଲେସନ ଆଉ ଟାଇମ ପାଇଁ ଆପଣ ମେନ୍ ପ୍ରୋବ୍ଲେମ କଣ ହେଲା କି ନାଉ ଇଫ କନସିଲେସନ ହାଜ ବିନ୍ ଦେୟାର ଦେନ୍ କିଛି ସାର୍ ଆରେ ଆପଣଙ୍କ ଲେଖା ହେଇନି କିଛି ସାର୍ ସେଟା ମୁଁ କହୁଛି ଆପଣ ପଢାନ୍ତୁ ଆଉ କାହାକୁ ଆପଣ ଯାହାକୁ ବି ଚାହିଁବେ ପଢାନ୍ତୁ ସେ କହିଲେ କନସିଲେସନ ରିପୋର୍ଟ ଇଜ ରିସିଭଡ୍ ଫ୍ରମ ଦ କନସିଲେଟର ଟିକେ ଲାଙ୍ଗୁଏଜ ଭୁଲ ଭାଲ ଲେଖା ହେଇଛି କାହିଁକି states that stated states that there is states it is stated there in a language problem अरे ठीक है सुनो तो सर look at the consideration of reports in order task the matter is referred due to non cooperation of the respondent so सेटा conciliator report लिखिले आपण जदी सेटा खराब कोन हला again conciliation is within the purview of the litigation ଆପଣ ଖୁସି ଆପଣ ରାଜି ହେବେ ନହେଲେ ରାଜି ନ ହେବେ ଏଗେନ୍ଷ୍ଟ କଣ ହେଇଗଲା
ମୁଁ ତ କନସିଲେସନ ପାଇଁ
କନସିଲେସନ ଫାଇଲ କରୁନାହାନ୍ତି ଜଏଣ୍ଟ ଆଫିଡେଭିଟ୍
ଜଏଣ୍ଟ
ଆପଣ ଯାହା କନସିଲେସନ ରେ ଚାହୁଁଛନ୍ତି ଆଇ ହୋପ ୟୁ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ ହ୍ୱାଟ ଆଇ ଏମ୍ ସେଇଂ ମୁଁ ଆପଣଙ୍କୁ କନସିଲେସନ କୁ ପଠେଇଲି ଗୋଟେ ମ୍ୟାଟରରେ ସେ ମିଷ୍ଟର ପୈଳାସ ମ୍ୟାଟର ଲାଷ୍ଟ ମ୍ୟାଟର I engage you as a conciliator, Ashwini Kumar Das.
Sir.
Now, Mr. Poida writes a report to me that due to you are say somebody ex member, Mr. Mahapatra is the respondent. You are the counsel, not the person. Mr. Poida gives a report that due to non-cooperation of the respondent, hey Palan. So can the Mr. Mahapatra will take exception?
No, I am not.
Now you say that conciliation darkar hachi. You file an affidavit, both of you. You must understand that এটা 25 মସିହାର কেস
Sir, why?
ଆପଣଙ୍କର 3-4 ଥର ଆଟେମ୍ପ୍ଟ ହେଇଥିବ
ଚାଲୁ ସାର୍ କୋଉ ଷ୍ଟେ ହେଇଛି ତ ଷ୍ଟେ ତ ମୁଁ ମାଗୁନି ଷ୍ଟେ ତ ହେଇନି
ସାର୍ ଷ୍ଟେ କଥା ନାହିଁ ଯେ ଆପଣ ଯୋଉ କହୁଛନ୍ତି କନସିଲେଟର ରିପୋର୍ଟ ମୁଁ କେମିତି ଆଇ ୱିଲ୍ ଡାଇରେକ୍ଟ ଆଇ ହାଭ୍ ଟୁ ଡିକ୍ଟେଟ୍ ଅର୍ଡର ଆପଣ ମତେ କହିଲେ ଏଟା ମୋ ଏଗେନ୍ଷ୍ଟ ଅବଜରଭେସନ କନସିଲିଏସନ ରେ ଶୁଣନ୍ତୁ ମିଷ୍ଟର ଦାସ କନସିଲିଏସନ ରେ whether anyone agrees or not conciliator gives a report
so my submission is let that be
ଆପଣଙ୍କ ସବମିଶନ ଗୁଡା ମତେ ଶୁଣି କଲେ ଭଲ ହୁଅନ୍ତା
sir ମ୍ୟାଡାମ ମୁଁ କପି ମାଇକ ଆଣିବି sir ରେଜେଣ୍ଟ ମାନେ ମୁଁ
କପି ଆଣିବା ଦରକାର ନାହିଁ ଆପଣ ସେଟା ବି ଗୋଟେ I was thinking those lines, but you must think what I am telling you. Conciliation ର conciliator ର report ଯୋଉଥିରେ failure ହଉଛି ତାପରେ କଣ compromise ହେଇପାରିବନି?
I want to know.
So what is against you?
My submission I want to know.
Now suppose conciliator says ଆପଣ extreme example ମତେ ବୁଝି ପାରିବେ ଆପଣ ବୁଝିବା ବଡ କଷ୍ଟ ବିଷୟ ଦାସ ଶୁଣନ୍ତୁ conciliator suppose writes a report that the husband is cruel.
No, I am not done that one.
अरे सुनिबेन तो आपण so now the consequence is that the court will say that husband is cruel 13-1 is proved
ना सेमती मु कोनी
ताले काई सोडा का आपण एटी कोर्ट रे कहउछन
गोटे जिंतो गोटे लेट मी
आपण सर गोटे शिरोनास्ति शिरोपीड़ा सर से कहिले जे कॉन्सिलेटर कहउचंती दे ड्यू टू नॉन कोऑपरेशन से जहा लिखिचंती सेरा कोन अपेलेबल ऑर्डर कॉन्सिलेटर को ऑर्डर
अपेलेबल कोनी
सर कॉन्सिलेशन इज द पार्ट ऑफ द एडजुडिकेटर्स
Yes, sir.
Pre-litigation,
that is my.
Sir, after litigation, during litigation, conciliation happens. आपण राजी होले नी
मु जदी
खुशी
जदी हेई तो भल मु से को दे
सेटा किंतु how can I compel somebody court को compel करबी
I don't want to compel whatever let him go for conciliation
no I cannot compel a court that is the mandate of the statute आपण केस रे विन करिवे आपण कोन चा आपण माने you are the wife or the husband in the marriage wife कोन चाहउछन आपण कोन होइछन
मु जदी कंसल्टेशन
चांस नहीं अपन से बाई के रहिबे ना अलगा रहिबे कोन होइछन
अलगा घर के चाहे सर औ आई वांट दैट इज व्हाई आई एम टेकिंग
सो ठीक अछि ताले आपण रजिस्टर करंतु सो द बेस्ट लोक पाखरे आपण अछन फैमिली कोर्ट जज कहबे सीपी के फाइल करले 13 ने के फाइल करले 13 ना 9 एटा 13 आपण 13 रजिस्टर करिवे 13 डिसमिस हे जिवो आपण गोटे वार्ड से लिखि देले जे ड्यू टू नॉन कोऑपरेशन ऑफ द रेस्पोंडेंट आपण तो हाई कोर्ट रे पहुंचले adjournment नियंतु सर बट मोर कहला कथा जे at times we must especially matrimonial matters रे the litigation has become aimless completely aimless directionless objectiveless किछि नै
उडी चांस देले
तब आपण भी वकील हिसाब रे एते कोन जज लिखि देले जे सेटा काहे लिखिले अरे से जगह कोर्ट कले
सेटा मु कोनी सेटा हे होई कि लिखा होई सॉरी वाला मन कोनी कैंसलेशन ओवर बोल कोनी
conciliation केमते आगे हबो conciliation पाइन the court will not detain itself for the you see the courts are under a lot of pressure from us from supreme court that matrimonial matters which affects families matrimonial matter रे आगे कोर्ट लोक इन्वॉल्व पुओ झियो तांका बापा मां फैमिली छोटो छुआ थिबे तांका ग्रैंड पेरेंट्स extended family so that is the reason why the courts are harping on disposal of the matrimonial matters
I don't
so that Mr. and you are taking exception jotre kichi nahi setere that is nothing against you
जदी गुटे दिन जाय देखा तब चालू सर कोन मोर किछ कहै
conciliation आपण का इंसिस्ट करचंती आपण जदी चाहउचंती compromise any kind of compromise आपण स्वामी स्त्री राजी अछंती को डिसीजन आगे मना करी
जणे चाहे सर
सेटा केमते हो ताले आ से कोन you can take the horse to the water you cannot make it drink आपण adjournment नियम
without conciliation is a day to adjourn
without conciliation no sir failure of conciliation you must understand that even to the extent we are monitoring how many cases are pending what is the status आपण बुझिया दरकार जे court cannot detain itself for the eternity that conciliation चालू छि तो चालू
दिने भी आइने डेटी से सती बेंग सर दैट इज व्हाई
आपण adjournment नियंतु देखंतु but I have done my part आपण सारे conciliation मु तो एटलीस्ट बहुत करछि आज जो हला कोन हला आपनकर एटा adjudication ना conciliation with Mr. Das with the judge it's conciliation जे why you are गोटे सेंटेंस से लिखिले भूलभाल हे पारे इंग्लिश
नहीं से भूल
the matter is referred due to non cooperation of respondent
I am not a
non cooperation जदी हला कोन हला सीटू
ना मु भूलभाल
अरे why you are taking exception to that आपण मेन प्लीट आपण 13 रे रजिस्टर करंतु
ठीक है
yes adjournment or disposal ठीक है can you just have your seat? I'll just dictate the order. ଆପଣ ତ କୌଣସି ପ୍ରୋଭିଜନ ବି କୋଟ କରିବେନି ଆପଣ କଣ ପ୍ରୋଭିଜନ ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କଲେଣି the petitioner the wife in the marriage is before this court ଏଥିରେ appearance like ଡାକିଛି Mr. Ashwini Kumar Das for the petitioner the wife in the marriage is before this court challenging the order dated 192025 passed by the Learned Judge Family Court, Sambalpur. Stuff. In CP number in CP number 83 of 2025. आपन को बुझे बुझे मोर भूलभाल सब हेगलानी
83
question say like in CP number 83 of 2025 stop the CP was filed by the CP has been filed by the husband in the marriage under section 9 of the section 13 of the Hindu Marriage Act seeking grant of seeking dissolution of marriage solemnized between the petitioner husband and the opposite party wife ହେଲା ଆପଣ ସେ ଆପ୍ଲିକେସନ ଟା ପରେ ଦେଇଥିଲେ କି କନସିଡରେସନ କୁ ଆଉଥରେ ପଠେଇବା ପାଇଁ କିଛି ପ୍ରୋଭିଜନ ଅଛି ମୁଁ ବି ଆଇ ଏମ୍ ନଟ୍ ସିଓର ମୁଁ ଜାଣିନି ଆକ୍ଚୁଆଲି ଇଟ୍ ଇଜ ଏ ଗେସ୍ ୱାର୍କ
ଓରାଲି ସବମିଟ୍ କରିଥିଲି ମ୍ୟାମ୍ ଏଟାକୁ ଦେଖେଇଥିଲି ସେ
ପିଟିସନ ଟା ଦେଲେନି ମୁଁ କହିପାରିବିନି ବିକଜ ଆଇ ଡୋଣ୍ଟ ଥିଙ୍କ ଦ୍ୟାଟ୍ ଇଜ ମୋର ଫ୍ୟାମିଲି କୋର୍ଟସ ଆକ୍ଟ ରେ ଯାହା ଯେତିକି ଅଛି ପଢିଛି ଆପଣ ଯଦି ତାଙ୍କୁ ଆପଣ ମେନ୍ ପ୍ରୋବ୍ଲେମ ହେଲା ଯେ ଆପଣ ତ ହଜବେଣ୍ଡ ୱାଇଫ ରାଜି ନୁହନ୍ତି ଆପଣ ଝଗଡା ଲାଗି କୋର୍ଟକୁ ଗଲେ ବର୍ତ୍ତମାନ କୋର୍ଟ ଯଦି କହିଲେ ଯେ
ଝଗଡା ବିଲକୁଲ ହେଇନି
ଆଉ ତାହେଲେ କାହିଁ କୋର୍ଟ ଯାଉଥିଲେ ତାହେଲେ ଓକିଲ ଅଛନ୍ତି କାହିଁ କଣ ପାଇଁ ତାହେଲେ the said order is reproduced here
କୋର୍ଟ ରେ କେସ୍ ଲଢୁଛନ୍ତି ଏଇଟା ଆଚ୍ଛା
192025 order ta quote kar dele the learned counsel for the petitioner takes exception to the observation as contained in the said order quote conciliation report is received from the conciliators stated that there is so and so up to WS by the respondent quote ends the learned counsel for the petitioner is heard at length. This court is of the opinion that the observation that the respondent has not cooperated in the conciliation does not in any way affect the merits of the case of the respondent in the pending CP. Stop. It has further to be noticed that after when 192025 the matter has been listed before the Learned Judge Family Court on 8/9/2025, 24/9/2025, 37/2025, 22/8/2025, 18/10/2025. Stop. Apparently, after passing of the order dated 192025, the court has proceeded further. The learned counsel for the petitioner has adjournment to address whether under any provision of law he can again approach the court for conciliation. So, Mr. Das, April ଆସିବ ସେଠି କଣ ନେଇକି ସେଟା ଆର୍ଜନ କରିବେ ଏଟା ଦେଖିକି ଏଟା କରାହେଇଛି କଣ ପାଇଁ କେସଟା 4 ତାରିଖ ଅଛି the matter shall be listed in the week commencing 30 ନା କଣ 6 ଜାରି हां केबे कहले 30 दिन आपण कोन चमकिलेनी यस
Item 9.
Abhilash Mishra for the petitioner.
Why the petition for my lord? It is selling the order dated 31/1/2026 on the register 8, wherein the Lion Judge Family Court Kanpur has modified its earlier order, but see, and
Reduce the maintenance.
my lord,
Reduce the maintenance.
no, my lord, it is relating to vegetation right of
Vegetation right. Okay.
my lord. The fact is that the husband initiated a proceeding of divorce under section divorce, and in pendency of the petition, husband had an application under section 26 of the Hindu Marriage Act claiming custody of the child. The present petition object.
नहीं आपण मोटे मु बुझ पाले के इनिशियल पिटिशन ता होची कोड सेक्शन 13 ना कस्टडी
Initial petition is section 13 initiated by the husband.
13 सेथरे 26 की फाइल कले
26 filed by the husband.
13 फाइल कले 26 because custody with the mother
And that
so सेथरे 26 रे कोन वेजिटेशन राइट मिलला
yes, my lord. Lord's guide.
कोन वेजिटेशन को ऑब्जेक्ट करचोंदी
Yes, my lord. The major.
सेदा आपण देखिबे ना केस ला किछि नाही रेतरे
No, Lordship, no. What happened? Vegetation was allowed. Lordship kind of allows to page 41.
yes 41
The ordering person, my lord. In view of the above findings, this court partly allows the interim custody application with the following directions. The petitioner, father, and his family members, that is, parents, are hereby granted visitation rights with the minor child on all the Sundays of every month for a period of 3 hours. The visitation shall take place in a neutral, child-friendly public location, that is, nearby Conquital Park, a children's play area within the jurisdiction of this court. The interaction shall take place under the supervision of a female court appointed commissioner, named such and such, a paralegal volunteer attached to the civil court, Kanpur, who shall ensure the child's safety and observe the behavior of both parties and bring the minor child and his mother OP to such place at the expenses of the petitioner. The petitioner.
Yes. Correct. Read further.
The petitioner shall be permitted to engage in video calls thrice a week, that is, every Monday, Wednesday, and Friday between 6:30 p.m. to 7 p.m. in the presence of the OP or any responsible adult in her family in her absence. However, upon that custody, that I am not concerned, my lord. Pursuant to this order, my lord, everything was going smoothly, and the next date of visitation was fixed to 26/10/2025. Lordship kindly goes to page 44.
I was at 44 years.
Yes, but the child who is 3 years old was suffering from illness on 21 and 28. Lordship, para 3, starting from the dot that in obedience to the above order, the petitioner, while fully cooperated, thereafter, why I filed the application for revocation of the order, my lord, that I filed, why I filed application for revocation of the order, that the visitation rate should be changed from park to the house of the wife, my lord. And he accepted, he pleaded that, my lord.
Contrary to law.
My lord.
Wife cannot decide when we need 26 petition, court has to decide and welfare of the child. So wife cannot decide the place.
Well, why have stated so, my lord? The reason I have mentioned, my lord.
No, you say, just make the point.
Yes.
Instead of reading so much, you straight away make the point.
My lord, the law is that a place which will be child friendly, neutral to both the parents, that should be the place. My lord, on my application.
So the first point, second point you are considering.
No, my lord.
Because neutral to both the parents, how your house is neutral to both the parents?
No, my house is not neutral, my lord.
So definitely, so obviously you are when you are saying
what the family just did, my lord. He partly allowed my application for modification. Now instead of earlier order, the visitation rate was fixed as par. Now, my lord, under impugned order, the visitation rate fixed as the PWD IP, my lord, which is not at a secure place in child friendly place, my lord. That is the order, my lord. That is the order. PWD IP.
आरंभ किए कला? Who paid for shifting of the park to house? Then you are arguing against yourself. You want if you are saying that it should be inside the premises of a house.
No, my lord. Not inside the premises.
अरे आपण निजे प्रेयर करछन inside the premises.
मो घर को आसु
काई ଆପଣଙ୍କ ଘରକୁ ଯେହେତୁ ଦିଆ ହବନି ସେଥିପାଇଁ ସରକାରଙ୍କ ଘରକୁ ମିଷ୍ଟର ମହାନ୍ତିଙ୍କ ଘରକୁ ଦିଆ ହେଇଛି।
PWD IP every day, my lord. The difficulty is that
PWDIB is 7 kilometers far away to my residence.
କୋଉ ଜାଗାଟା କହିଲେ PWD?
My lord, Rampur PWDIB.
ମଦନପୁର ରାମପୁର?
No, Sonpur Rampur.
ସୋନପୁରରେ?
My lord. ମୋ ଘରଠୁ 7 kilometers
ଆପଣଙ୍କ ଘରଟା କୋଉଠି? ତାହେଲେ ଆପଣଙ୍କ ଘରକୁ ସେ କେମିତି ଯିବେ?
No, my lord.
ଆରେ ତାଙ୍କ ଯେହେତୁ you are not agreeing for the public park nearby, you are praying for your house.
Yes.
Then the court has given Mr. Mohanty's house.
No, my lord. Park smoothly ମୁଁ କରିଥିଲି. It's because due to my health condition.
ଆପଣଙ୍କର health concern ଯଦି ରହୁଛି ଆପଣ ଘର ଚାହୁଁଛନ୍ତି ତାହେଲେ କୋର୍ଟ ତ ତା ନିଜ ଘରକୁ ଡାକିବେନି।
My only concern is that
ଆପଣ କୋଉ ଘର ତାହେଲେ କହିବେ?
instead of temple or any କଲ୍ୟାଣ
No. କଲ୍ୟାଣ ମଣ୍ଡପରେ କଣ ମ? କଲ୍ୟାଣ ମଣ୍ଡପରେ ମିଷ୍ଟର ଆର୍ୟାଙ୍କର ପାର୍ଟି ହଉଥିବ ଆପଣ ଛୁଆ ଯାଇ କଣ କରିବ? ଟେମ୍ପୁଲରେ କଣ ହବ? ପୂଜା କରିବ 3 ବର୍ଷର ଛୁଆ? Sir, these are all fantastic and figment of imagination. Temple is most conducive for the child. ଆପଣ ଯଦି ଘର ଚାହୁଁଛନ୍ତି ମହାନ୍ତିଙ୍କ ଘର କଣ ଖରାପ?
PWDIB everyday government occupation.
ସେଇଟା ମୁଁ ସେଥିପାଇଁ ପଚାରିଲି ଆପଣ PWD ଜାଣିନନ୍ତି ମୁଁ ଜାଣିଥିବି ସେଥିପାଇଁ PWD ରେ କିଛି ଶୁଣନ୍ତୁ ସେଇଥିପାଇଁ ତ କୋର୍ଟ ହିଁ ଅର୍ଡର କରିଛନ୍ତି। ଆଚ୍ଛା କୋର୍ଟ କାହା ଘର ଇଣ୍ଟ୍ରୁଡ କରିପାରିବେ? କୋର୍ଟ ତ କାହାକୁ କହିପାରିବେନି। କୋର୍ଟ କହିପାରିବେ ସରକାରଙ୍କୁ। କଣ କରିବେ? କଣ କୋର୍ଟ କହିବେ? ହସ୍ପିଟାଲ କହିବେ? Then so at least the court is innovative. ଯୋଉ ବିଚିତ୍ର ଆର୍ଗୁମେଣ୍ଟ ପିଲା ମାନେ ବାପା ମାଙ୍କର ମୁଁ ଲୟରଙ୍କର କହୁନି ଆପଣଙ୍କର ଇନଫ୍ୟାକ୍ଟ ଦେयर ଇଜ ଏ ରିସ୍କ ଅଫ ଆପଣ ମାନେ କୋଉଠି ଘରକୁ ଗଲେ ଝଗଡା ବି ହେଇଯିବ। ଆପଣ ମାନେ ଦେ ଆର୍ ନଟ୍ ଶୁଣନ୍ତୁ କୋର୍ଟ ଆପଣ ଦିସ୍ ଇଜ ରାଦର ୟୁ ସୁଡ୍ ଥ୍ୟାଙ୍କ ଦ ମାନେ ଜଜ୍ ଯେ ସିଏ ତ ଆପଣଙ୍କର କୋଉଠି ଆପଣଙ୍କର ଚିଲଡ୍ରେନ୍ସ ପାର୍କରେ ନହେଲେ ନେବେ ଖୋଲାରେ ଆପଣ ମନା କରୁଛନ୍ତି। ଆପଣ ଯଦି ଆପଣ ସେଟା ପ୍ରେୟାର କଲେ କରୁନାହାନ୍ତି ସେଠି ଆପଣ ପ୍ରେୟାର କଲେ ମୋ ଘରକୁ ଆସିବ ଛୁଆର ଦେହ ଭଲ ନାହିଁ ସେଠୁ ସିଏ କହିଲେ ଯେ ଆପଣଙ୍କ ଘର କ୍ୟାନ୍ ନେଭର ବି ଟୁ ବି ନ୍ୟୁଟ୍ରାଲ ହାଉସ। ଆଚ୍ଛା କୋର୍ଟ କୋଉଠି କରିପାରିବେ? କୋର୍ଟ ଡଜଣ୍ଟ ହାଭ୍ ଏନି କେୟାର ଆଣ୍ଡ କଷ୍ଟଡି ଅର କଣ୍ଟ୍ରୋଲ ଓଭର ଏନି ଅଦର ହାଉସ ଦେନ୍ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ପ୍ରପର୍ଟି। ସେଠୁ ନିୟର ବାଇ ଭଲ ଜାଗାକୁ ସେ PWDIB କହିଛନ୍ତି। PWDIB ଆପଣ ମାନେ ରହିବେ ଆମେ ସେ ଛୁଆ ରହିବାରେ କଣ ଅସୁବିଧା ଅଛି?
Distance between my house to PWD 7 kilometers.
That is immaterial. ଆପଣଙ୍କର you are fighting for custody ଆପଣଙ୍କ କଷ୍ଟଡି ଅଛି ଆପଣ ଭେଜିଟେସନ ରାଇଟ
କିନ୍ତୁ ଆଜ୍ଞା ଏଭ୍ରି ସଣ୍ଡେ ରେ
ସେଇଟା ସିଏ କମ୍ପ୍ଲେନ କରିବା କଥା। PWDIB ରେ 3 ଘଣ୍ଟା ମାସକୁ ହେଲେ କେତେଟା? 12 ଘଣ୍ଟା। ବାକି ଯୋଉ ଆପଣଙ୍କର ମାନେ 12 ଘଣ୍ଟା ପରେ 30 ଦିନ 29 days and 36 hours ଆପଣଙ୍କ ସାଙ୍ଗରେ ଛୁଆ ରହିଲା ସେଇଟା ହଜବେଣ୍ଡ କମ୍ପ୍ଲେନ କରିପାରିବେ ଯେ ଆଜ୍ଞା ମତେ ତା ବି ଦଉନାହାନ୍ତି ସେ ଆପଣ ବି କମ୍ପ୍ଲେନ କରୁଛନ୍ତି ଯେ ନାଇଁ ମୋ ସାଙ୍ଗରେ ଛୁଆ ରହିଲା 29 ଦିନ 36 ଘଣ୍ଟା ମାସକୁ 12 ଘଣ୍ଟା କି ଯଦି 5 ଦିନଟା 5ଟା ସଣ୍ଡେ ହେଲା ସେ ରହିବ 15 ଘଣ୍ଟା ସେଥିରେ ବି ଆପଣ ସେଠିରେ କମ୍ପ୍ରମାଇଜ କରିବାକୁ ରାଜି ନୁହନ୍ତି। ସାର୍ ଆପଣଙ୍କର ଧର maybe sitting in High Court I will say that some children's park in Cuttack ସୋନପୁରରେ କଣ ଅଛି ସେଟା ମୁଁ ଖୋଜି ବାହାର କରିବି। No, nothing. PWDIB ବାଲା ଯଦି ସେମାନେ ମିଷ୍ଟର ମହାନ୍ତି ମେ କମ୍ ଅପ୍ ୱିଥ୍ ଆପ୍ଲିକେସନ ଯେ ଆଜ୍ଞା ଆମ ଆଇବି ରେ କାହିଁକି ହବ ସେଇଟା ଅଲଗା କଥା। ଆପଣ you do not have a choice there. Sir, you are having custody. The father you must understand the father is put to harassment by this.
I'm not understand the vegetation, my lord. But the PWDIB is
not at your choice. ସବୁ ତ ଆପଣଙ୍କର ହବ ତାହେଲେ ଆଉ ଛୁଆଟେ ବି ଆପଣଙ୍କର କଷ୍ଟଡି ଆପଣଙ୍କର ଭେଜିଟେସନ ବି ଆପଣଙ୍କର। What is this logic? Sir, he is the father. He has equal right. ଯଦି even court କହିବେ ଯେ ultimate custody 5 ଦିନ ଆପଣଙ୍କୁ ଦିଆଯିବ ତାଙ୍କୁ 5 ଦିନ ଦିଆଯିବ। So then what is the difficulty in a government venue?
But my lord, the 7 kilometers distance.
7 kilometers or 70 kilometers was initiated by you when the order was dictated. Here
my lord,
in many cases, Mr. Mishra, when the order is dictated, you are withdrawing the petition. Why? You are avoiding the order. You are insisting that nahi seta mo amo ghare hobo park re hei pariboni. The court doesn't have a choice. Rather the husband should be aggrieved that agya mate PWDIB jiya pai kaleni and maybe PWDIB Mr. Mohanty will say something. I mean whoever he is the counsel. Luckily he knowledge the agu dei thanda fer se problem hedanta ta na bhi koi na thanda. Here you have to wear the hat of conciliator. It is a non-issue case. Like Mr. Das, today I don't know, Mr. Das also took that exception, they say non-cooperation conciliation hayni. Now you are saying that the vegetation right, you are having custody.
My lord.
You are now even, see, he is fighting for custody and vegetation right. PWD ରେ ହବ ଅସୁବିଧା କଣ ହେଲା ସେଠି? ସାର୍ କୋଉଠି ଗୋଟେ ଭଲ ଜାଗା ଫେର ଖୋଜିବାକୁ ପଡିବ। ହଁ ଆପଣ 10ଟା ଜାଗା କହିଥାନ୍ତେ ସେ ତା ଦେହରୁ ବାଛିଥାନ୍ତେ ସେ ବି ଗୋଟେ କଥା। ଆପଣଙ୍କ ତ ଆଗ୍ରିମେଣ୍ଟ ବିଲକୁଲ semblance of agreement ନାହିଁ। Tabi, you must understand the difficulty. Now, Mr. Mishra, suppose in this case, you are arguing the same thing. Suppose I am the family judge. Now you just think that if you are not suggesting any place in Sonpur, in and around Sonpur, what answer the court will have? Nothing. It's
the largest on the part of the Consulting Council.
No. They are not listening.
But my lord, the endeavor should
Sir,
to bring all the.
I don't know. Se jo ଛୁଆର ମା ଯାଇକି ସେ ଓକିଲ ଘରେ ହଙ୍ଗାମା କରିଥିବେ ଯେ ସେ ଆମ ଘରକୁ ଆସିବେନି କାହିଁକି ଆମ ଘରକୁ ଆସିବ so what is there you cannot say exactly it is so easy to blame the lawyer but ମାନେ this is a non-issue, absolute non-issue. ଆପଣଙ୍କର even one day ବି ହଉନି ଗୋଟେ ମାସରେ ଗୋଟେ ତାର ବାପା ପାଖରେ ଛୁଆଟା ଗୋଟେ ଦିନ ବି ରହୁନି 12 ଘଣ୍ଟା କି 15 ଘଣ୍ଟା ରହୁଛି ସେଥିପାଇଁ he has to fight it out. And it is not that he has to suggest because it is your prayer. You make a prayer that it has to be at a closed premises inside a house. What can be done? Acha, how it is in short. जो conditions are imposed that amicus should be there, he will observe everyone. Those conditions are already there. Even the
But my lord, I am also challenging that the video call, my lord.
Video call, you have to read the law. You are expected to read the law.
10 minutes,
I think that there is no guidelines in that. Supreme Court has said many things. You have to examine the law.
Yes, ma'am.
Video call, there is no case. This is only thing is that whether you have received your fees or not. That is enough. If it is engaged by a lawyer, you will not get the fees also.
So, yes, from my chamber, Sonpur chamber.
Sonpur chamber. So then you have received the fees. That is enough.
Let's keep it to.
No, there is no case, sir.
Let's keep it. Sir, regarding the video call,
video call, I will not. You have to go to Supreme Court. Sir, which High Court will prevent the father? Sir, your outright I can reject with reasons. But the mother wants that how much time on Wednesday, Monday, Wednesday, Friday.
Half an hour.
I will make it 1 hour, like Supreme Court. It should be. You are in most of the courts. You yourself are talking for 1 hour.
Yes.
The client is talking for your client is talking for 1 hour.
Yes.
This is most inhuman conduct of the mother. I'll record that. It is a inhuman condition to impose that the father talking with the child, minor child, for half an hour is perceived to be excess by the wife, by the mother. That I will observe and impose cost. Is it fit case? Nothing. I'll keep it, but I have a difficulty in forgetting. You can't re-argue the matter.
Yes, madam.
You take adjournment, nothing.
I have a level based manual.
No, you have tried. In a case where there is no semblance of merit factually, it is absurdity actually. This is absurd logic. Suppose I believe you and I trust. Suppose let us assume the other way. I am persuaded by your argument. I will record these things that he is half an hour is excess. The mother wants that the vegetation should be at a particular home. PWD ID is bad. Then how can I say PWD ID? Because I myself I do not know.
Clearly, I am submitting. Since day one, I am not insisting for filing the petition. The lady who is working, a working lady, insisted me for challenging that.
Sir, that's the problem. You have to elevate yourself. And because the court, at least you can take the court's name. Because see to sunanti Bekaria judge. अरे कौन करिवे कौन करिवे सेतरे कौन अछि सेतरे कौन करिवे आपण absurd गोटे कथाटा गोटे किछि ना माने दिस इज ए endless litigation आपण you are making the child a pawn आपण you must tell your client this child will ask her that where is my father
now
you must understand because se बर्तन तो बयस केते छुआर
3 वर्ष
सेट पे हे सब जिंस चलछि ଯେତେବେଳେ ଛୁଆ ଘରେ ବସିକି ବସିବ କହିବ ଯେ ମୋ ବାପା ସାଙ୍ଗରେ କଥା ହେବି ସେଇଥିରେ ସେ ବୁଝିଯିବେ କଣ କଣ କରୁଛନ୍ତି କଣ
Definitely.
ଆରେ you ask her that what is her relationship with her father.
And my lord, entire disruption because of ego.
Ego madness also. ଆପଣ ଗୋଟେ father after you become a mother you deprive the father of the visitation right.
Never.
You are taking exception 3 to ଅଧଘଣ୍ଟା ବେଶୀ ହେଇଗଲା property vis-a-vis the father and the mother the child is a property chattel.
So in the meantime, I will advise that joint application be made for mutual place. I will advise both the parties.
I don't know whatever you do that is not a good I mean this is thanks to the family judge he is able to keep his sanity.
Yes.
The useless cases are being argued before the he or she I don't know he must be spending time in adjudicating what is the exact location. ଆପଣଙ୍କ convenient place ଟା କୋଉଠୁ ଆଣିବେ court cannot get it convenient. Mr. Abhilash Mishra for the appearance actually was. You take your seat, I'll dictate the order. The petitioner, mother of the child, wife of the mother of the child, the petitioner is the mother of the child born from the wedlock born from her wedlock with the opposite party husband. ମଦରଙ୍କର କଣ ବିଜନେସ ହେରିକା ଅଛି କି ମଦରଙ୍କର ବେଶୀ ବିଜନେସ ପଇସା ଅଛି ନା କଣ ସବୁ
Mother is also working. He is a teacher.
କଣ ପାଠ ପଢଉଥିବେ ଭଗବାନଙ୍କୁ ଜଣାছে ପ୍ରଭୁର born from her wedlock opposite party who is her husband. Stop. The opposite party has instituted a case before the learned judge family court Sonpur under section 13 into bracket 1 into bracket small I Roman I into bracket closed I-A bracket closed read with section 7 of the Family Courts Act. Stop. During pendency of the petition under section 13 the opposite party, father of the child, has filed petition under section 26 of the Hindu Marriage Act seeking custody of the minor son who stays with her mother. During pendency of the section the section 13 and under section 26 both are pending adjudication. IA number 1 of 2025 was filed before the learned judge family court seeking interim custody of the minor child. Stop. Interim custody application has been disposed of with direction giving visitation rights to the father petitioner as well as contact rights over phone. এটা କୋଉ ଜାଗାରେ ଅପରେଟିଭ ପୋର୍ସନ ଟା
Disposal.
पेज କେତେ କହିଲେ 40 41 अच्छा ठीक है it should be you made your effort and I mean it is very difficult but these are not the cases to be kept pending. This is complete lack of, I mean, not bona fide, but a complete lack of the direction. इतने से जो लेडी जी से कौन करूँ से नहीं जानना है इतनी इरेक्टिक हमारे भी किसी नहीं that he is not a sick माने मु कमेंट करूनी बट आपण गोटे छुआर भी केयर नवार तांकर मते लागुनी क्षमता अछि बोली तो सबुदिन नुआ नुआ कथा कहउछन इतने छुआर ऊपर अल्टीमेट बहुत इंपैक्ट पड़ियो आपण गोटे हेल्दी ग्रोन अप चाइल्ड पे बोथ पेरेंट्स आर पेरेंटिंग इज एन आर्ट हाउ सक्सेसफुल वी कैनॉट से वाज पेरेंट्स किंतु एभलिया करे कथा नो किछि असुविधा होबनी आपण त बुझिया दरकार जे जदि छुआ तार बापा को चिन्हिला किछि असुविधा नै तार पर्सनालिटी डेवलपमेंट होबनी वो हो कि जियो तापर सी निजे वर्किंग लेडी सी केते समय जे देबे ताकर बापा मा माने पुअर अजाई कि मामू माई मौसा मौसी भलिया तक देखिया पड़ियो से भलिया जगह आपण बाप तो दूर के रखिया तो जोडे एजेंडा रहला कोन माने इरेटिक पूरा इरेटिक बिहेवियर एनीवे आपण प्रथम ऑर्डर ता होची पेज 41 लेकिन the operative portion of the said order is reproduced here in para 8 achi page 41 re in view of the above findings to neki necessary action पर्यंत कोर्ट तो डीएलएस को लगेले ताकर पैरालीगल वॉलंटरी को आनिले एटा केते कोन करि परिबे हटा देखला को आपनकर सब जाक किछ दिन पर कोन कहले हम जो जाउचू डिस्ट्रिक्ट विजिट रे आ आईबी नथिबो आईबी रे रहउथिबे आपनकर छुआंगर विजिटेशन राइट जोटा आपन कहले ने उल्टा ता हो तने कोर्ट ऑर्डर हम प्रोटेक्ट कर परिबे
मालडो माने आउट ऑफ कोर्ट मालड
कोन करा जो नहीं you are very candid in telling the things. But this is a very peculiar situation where I never expected this should go to that extent. I find it really very, I mean, unusual. कौन लिखले? अपन को कोट कर देले. The modification केबे फाइल करले अपन? पूरा modification application टा?
Modification मालड. At page
43. Thereafter, IA number 7 of IA number 7 number पड़ी नहीं अच्छा. Page 43 रहा. IA number 7 से ठीक अच्छी.
Yes, madam.
IA number 7 of 2025 has been filed. Seeking modification of the order.
Yes.
Earlier order.
Seeking revocation of the order.
So revocation file कर देला. ठीक अच्छी. Revocation of the order dated FT. Granting vegetation rights. In fact, that rights जो interim custody सेटा नो सेटा vegetation right.
Yes. मतलब
Contact right होची phone टा. Anyway, मैं correct कर देंगे.
मतलब से जो
चला. Seeking revocation of the earlier order dated 12/9/2025. Passed in IA number 01 of 2025. Stop. से revocation order टा कोथरे हैला तापर 31/1/26.
Yes, madam.
The said IA seeking revocation of the earlier order has been disposed of by order dated 31/1/2026. That is page 47.
Page 47, relevant portion, page 51. Starting from the word rejected.
With the following observations, resultantly, comma, page 51 re achi. Third subpara, resultantly to neki concert. No order as to cost and ordered accordingly. Saying all in the present application, the petitioner has inter alia contended that the distance of the PWD IB as directed by the court is about 7 kilometers from her house. He also takes exception to the father of the child talking to the child for half an hour when in contact over phone on Monday, Wednesday, Friday. On Monday, Wednesday, Friday. Para. In considered view of this court, the learned Judge Family Court has passed a very reasonable order considering the attitude of the parties, particularly the petitioner. The petitioner has herself sought for the child, the vegetation to take place in a house, and she had suggested her own house. Since the concept of granting vegetation is usually at a neutral venue, the learned court has found out an alternative like the inspection bungalow of the Department of PWD, of the Public Works Department, of the Public Works Department. Para. This court sitting in the great jurisdiction cannot delve into the matter whether the PWD IB, which is usually a well-maintained place and well-guarded place, is one of the alternatives for the vegetation to take place. So, but the vegetation at the IB has been granted at the instance of the mother who did not want the child to be visited at a place like Children's Park. Agur kon apar place thila? Children's Park thila. Children's Park. Stop. So, but this stage, the Lord Counsel for the petitioner submits that the petitioner would not press the application. Apar press ko na dispose of kar debi. Dismiss kar debi kon. Stop. Para. Regarding the contentions raised that the contact over phone is excessive, the matter is to be looked into its proper perspective. The mother of the child is having the custody for the entire period. If a month is taken as the unit, the mother has custody for all the days except 12-15 hours that is allowed to the father. Regarding contact with the child, it has to be and is noticed that the mother is having 24/7 contact all the days. The father, who is the natural guardian, also accepted and defined in the statutes, is having contact over phone half an hour on 3 days in a week. So that would add up to half an hour on 12 days in every month. By any stretch of imagination, it can be said that grant of half an hour contact over phone is excessive. Stop. The vegetation place has been directed by the court, taking into account the contention of the mother of the child, that it should be at a place which is like a built up house and not a park. No purpose a case is made out for issuance of notice. Rather, looking at the material on record, it has to be held that the orders passed by the judge family court dated so and so are just and proper and not to be interfered with. The petition is dismissed.
Since my lord, that the subsequent I has been filed for compelling reasons due to health condition. If I address my lord the health condition, if there are such arises, that should be taken care of.
First of all, as a principle, never bring the health of the child into issue, because mother is better equipped to take care of the health of the child. It cannot be the, you never know what would happen. So those things, you don't entertain them. ଆପଣ ରିଫ୍ୟୁଜ କରନ୍ତୁ ଆଗ, ବାପା ନେଇକି ଯିବେନି ହସ୍ପିଟାଲ, ସେ କଣ ଅଛି କି? ରାଦର ଏନକରେଜ କରନ୍ତୁ ଯେ ଛୁଆଟା ମାଧ୍ୟମ ହବ ବାପା ମାଙ୍କର ଭଲରେ କଥାବାର୍ତ୍ତା ହବା ପାଇଁ। ଆପଣ ତ ଗାର୍ଡେନରୁ ଯାଇକି ପିଡବ୍ଲ୍ୟୁଡି ମିଷ୍ଟର ଲେଙ୍କାଙ୍କ ଘରେ ପହଞ୍ଚିଲେଣି, ମିଷ୍ଟର ମହାନ୍ତି ପଳେଇଲେ, ମୁଁ ଯେମିତି ତାଙ୍କ ଘରେ କହିଲି ସେ ଉଠିକି ପଳେଇଲେଣି, କୋଉଠି ଛାଡି ପଳେଇଲେ। ସେ ବର୍ତ୍ତମାନ ଆଜ୍ଞା କୋଉଠୁ ଆଣିକି ଘର ତାହେଲେ କୋଉଠି ଦେଖା ହବ ତାହେଲେ? ମିଶ୍ର କ୍ୱେଶ୍ଚିନ୍ କରୁଛନ୍ତି ପିଡବ୍ଲ୍ୟୁଡି ହେଲା ଦୂର ହେଇଗଲା, ମା କହିଲେ ଯେ ଗାର୍ଡେନରେ ହବନି, ପବ୍ଲିକ ମାନେ ଚିଲଡ୍ରେନ୍ସ ପ୍ଲେ ଗ୍ରାଉଣ୍ଡ ହବନି, ଗୋଟେ ଘରେ ହବ, ମୋ ଘରେ ହବ, ନ୍ୟୁଟ୍ରାଲ ଭେନ୍ୟୁ। ସେ ପିଡବ୍ଲ୍ୟୁଡି କହିଦେଲେ, ଆଉ କଣ କରିବେ? ଆଉ ଚାଇଲ୍ଡ ୱେଲଫେୟାର ହୋମକୁ ପଠେଇବା କଥା ନୁହଁ, because the child will be scared. Any confined juvenile justice, now the principle is you have to take the juvenile from out of that process. Confinement and the play home हमको सबको अच्छी, I mean they are retained there. पिलांको सबले खोला छड़िया कथा। अपन तो कहले घरे रखंतु पिला देह खराब होछ। अपन जो पार्टी करना ना अपन नोटिस करे पड़ता है।
एकदम 10
सर
स्मॉल मैटर मिला
सर, आप दिनो रखंतु ऑलरेडी 4:35
I may be pardon my lord.
only early disposal.
अर्ली डिस्पोजल तो जदि आपनकर आईसीटी हबो आ ये हे परियो, अर्ली डिस्पोजल डायरेक्शन तो हे परियो। सुप्रीम कोर्ट हैज कंप्लीटली एक्सप्रेस्ड सेटिंग हे परियो। सेट से ऑर्डर पे सुप्रीम कोर्ट द लैंग्वेज सुप्रीम कोर्ट हैज यूज्ड, आपण विल बी सरप्राइज्ड।
सेटिंग और उसमें डिस्पोजल
ठीक है तो according to the माने बोर्ड माने number of matters pending there, it will be as expeditiously as possible.
2020
से कोऑपरेट करिवे। आपनकर प्रॉब्लम होची 20 रा मैटर तो 22 तो आपनकर 19 15 रा मैटर पेंडिंग अछि।
21 ले मो रेस्टिट्यूशन फाइल
करेक्ट
ना मा रेस्टिट्यूशन एला वाला से जॉइन कला ने तापर सीपी फाइल करले।
So item 10 disposed of
माने
item expeditious, but I have to note those judgments. Whenever a prayer is made before this court, that expeditious disposal, the judgment of the Constitution bench as well as Justice Oak's judgment, I reproduce those judgments that this court cannot direct. Yes.
item expeditious
ता छोड़ा expeditious cooperate करिवे, both the parties will cooperate, and ICT. जो information and communication technology, that remote location deposition, participating in VC, all those things अपन application देले यदि हे परियो।
My lord, may I pray, my lord?
Item number 18.
We touch.
May I pray, my lord?
Just mention sorry जरूर करिए।
item 13 person में टूल साहब
11 to 14
एकदम क्रूएल।
The PTS of will be taken up Tuesday.
Tuesday कौन है परियो?
Yes, PTS license.
Sir,
item
आपनकर अपन केते फाइल कलेगी 26 में Tuesday माने को बार कहउछन?
Next week only 2 working days.
2 working days problem sir, next week रे से रखि दै छन 67 टा। मु जोडा एंटिसिपेट करथिली से आई हला। आ तापर मेमो थिबो अन्य जिंस थिबो हमर एई तो जो हमें ट्रैक करूछु जेति कि हमें एडजॉर्न करिछु। बुझ परछोंदी केना केते मैटर आड होता हमें कोइ परिबो नो। So she already subject रखी दी छो.
लाइसेंस टा कैंसिल कर देबी अपील डिसमिस अपील टा डिसमिस हो जाई
सेटा तो फाइनल तो किसी अर्जेंसी नहीं.
आगे
मु को लाइसेंस दे देबी. लाइसेंस देबे मिस्टर लेंका. अरे मु को लाइसेंस दियो तो तथास्तु. So Arya is coming after a long time तो दियो तो लाइसेंस दियो. So जो तेरे पेंडिंग था से आसुन आगे एक्सपेडिशियस डिस्पोजल मोर इंटरिम ऑर्डर कंसीडरेशन होनी. मते ड्यूरिंग पेंडेंसी ऑफ द केस कंसीडर करा जाए मु कहबी. सी जाजपुर बर्तन संगे संगे सफा कर देले केस.
मते अपॉर्चुनिटी न देकरी कर दी
से मिस्टर सिद्धार्थ मिश्रा आर्ग्यूड दैट एम्फेटिकली से किछ हलानी. चैलेंज है कि से काउंटर फेल करियो बर्तन चलिबो. काउंटर हबो ये हबो सेटा फाइनल हियरिंग मैटर. सिथिर इंटरिम ऑर्डर कोन आई होप यू आर नाउ सीजन्ड. सो टू मच सीजन काउंसिल
स्टे ऑफ द
स्टे कोन होता ताल तो फाइनल डिस्पोजल हे गला. अपन फाइनल ऑर्डर स्टे माने कोन यू आर नाउ ये
allowing the writ
allowing the writ petition. केबे डेट करंतु 11/12 डेट कर दियंतु केबे 23 4 16 4 कर 16 23 कहउछंती
एई मास 30 भीतर से हम
30 रे कोन सर आबो कैंसिल थरे जे ऑर्डर हेला पर ताकू विदाउट
करी ना
एटा प्लीडिंग्स दरकार. अपन एटा प्रिवेंटिव हो ना कोन स्टे नो एक्शन शैल बी टेकन अगेंस्ट द डीलर. इति को हुए हिलेरियस ऑर्डर अपन को मागले और 23 कहउछंती अप्रैल स्पेसिफिक डेट नहीं वी कमेंसिंग करिए कर दियंतु जेबे आसीओ लिस्ट टू कटि जियो फेर
मैं पे बैक में
वी कमेंसिंग 24
आइटम 13 लॉटशिप तो हिसाब कर
13 कर दियंतु.
माय लॉर्ड आइटम लास्ट आइटम माय
कोन जेतु टाइम नहीं त छाड़ दियंतु तो डेट कर दियंतु
34 माय लॉर्ड.
अपन ताले मिस्टर दास ने भी 13 4 कर दियंतु. 13 4 कर दियंतु 11 12 13 टा को 20 4 कर दियंतु. मिस्टर महापात्र आर्गुमेंट करिवे नै त कोन थिला कि
एथरे
ए आकरी होया मिस्टर मिश्र होया केस करे
एथरे गार्डियन
जम्मा देखा करिवेनी बापा
जे
मदर करे जे फादर करे मदर देखा हबो
गार्डियनशिप डिस्कस फाइल करली
ठीक है
ग्राउंड ऑफ मैटर
इट्स इन अ लाइटर वेन ऑलरेडी यू हैव एक्सीडेड रियली एक्सीडेड द टाइम
27 लास्ट मोटे जजमेंट देखिबी ताको सेतरे ओटा सेक्शन 9
जजमेंट उभय साइड रे अछि इट्स अ डेलिकेट थिंग
आई सते करले सेक्शन 9 ले जो ग्राउंड से रिजेक्ट करते
देन आइटम 14 रो 14 रो 19
It's 17.
Yes.
Yeah, because amendment matter. Certain developments have been made.
सिंपल एडजस्टमेंट ही जो ऑर्डर तो करी होबनी तनु 17 टा डेट कर दियो
24
4
18 टा भी 24 को था इंट्री ऑर्डर
सर इंट्री ऑर्डर इंटरफेयरिंग ऑलरेडी पॉजिटिव ऑफ टाइम
तथा ठीक है.
सो इंट्री ऑर्डर विल कंटिन्यू if it is till next date or adjournment then
नहीं हम such it is.
no many times you are fixing a date of adjournment then obviously it has to be item 20 लेखन तो
19 also 24
आगे 19 को 20 सबुडा 20 4 दियंतु नि काली जहा थिला सब 20 4 कर देछो तो आपण बहुत दे गेलनि 20 4 27 4 कुड़िया ऑर्डर लिखंतु मिस्टर अरुण कुमार दास फॉर द पिटिशनर द मेथड being in the list is mentioned as it could not reach due to paucity of time. Stop. The requisites as directed by Kode number na.
Okay.
The requisites as directed by 22 22 12 20 passed by the coordinate bench. The requisites directed to be filed by the coordinate bench by order dated 22 12 20 have not been completely filed. Stop. Accordingly, it is prayed by the learned counsel for the petitioner. Further time may be granted. Stop. The requisites, complete requisites be filed within 7 working days. Stop. Upon filing of the requisites, notices shall be issued to the opposite parties. list after SR reported to mention. By C. Item 22 simply posting करते हैं ठीक से ऑर्डर दरकार नहीं यदि नोटिस सफिशिएंट है क्या
Notice survey.
Yes sir.
Last item.
24 34 just 1 second on 27
That is, yes, without informing.
27 टा 27 टा आपनकर Ms. Soma Patnaik for the petitioner, Mr. Amarendra Prasad Ray for the opposite party. The matter being in the list is mentioned by the learned counsel for the parties. Learned counsel may look into MS Patnaik as well as Mr. Ray. MS Patnaik for the petitioner and Mr. Ray for the opposite party. IA has been filed. IA number 4827 of 2026 has been filed by the petitioner enclosing letter dated 1/12/2025. Office letter dated 1/12/2025 issued by the Regional Director, Employees State Insurance Corporation, into bracket Ministry of Labour and Employment, Government of India, comma, Regional Office, Odisha, Bhubaneswar. Stop. এটা কভার এই অর্ডার করতে এটা ଆପଣ আইএটা ଆପଣ ତ ରିସିଭ କରିଛନ୍ତି ତ ଆଇଏ ନଟ୍ ଦୋ ତାପରେ ଗୋଟେ ଲାଇନ ଆଡ୍ କରିବେ ଦ ଆଇଏ ୱାଜ ନଟ୍ listed. The IE was not placed on record and the same has been received in the court from the registry. Yes.
Item 25.
Yes, please. 25.
25. I admit he last time. The exemption of portfolio. I
ask you, sir, ଚାରିଟା 15 ଟାଇମ୍ ସରିଲାଣି ନା ଗୋଟେ ମ୍ୟାଟର ମୁଁ ଡିକ୍ଟେସନ ଦଉଥିଲି ରହିଗଲା ଯୋଉଟାକୁ ମେନସନ ହେଇଥିଲା ମୁଁ ସେଇଟା ଅର୍ଡର କରୁଛି फास्ट माने दीटा बेले तो फास्ट आपरे ही पारलानी सो मेंशन जोडा मेंशन ऑलरेडी ही जाईची सेडा ऑर्डर तो सर कोन डेट करंतु 25
27 sir.
वी कमेंसिंग 27 4
Item 34.
34 सर से 4 मिस्टर सुंदर है से 4 5 कहले की मेंशन करथिले करिया सर सेटा तो होनी आउ सर एक्चुअली जेती आफ्टर नोटिस मैटर आपण 25 26 मसिया रो केबे भी सेटा कंप्यूटर रे ऊपर को आस परिबो हमें कोन एंट्री करछु की एटा ओटा ऑटोमेटेड सॉफ्टवेयर रे होउछ एप्रिल आपण हे की कोन 27 4 कहला जा 24 4 हवा से
Your lordship has মানে granted interim order till Monday, till Monday 23.
34 टा रे मंडे ऑर्डर सेटा अलग कथा सेटा से किछि कहि ना मते देखियो पड़ियो आपण जोटा कहउछंती मिस्टर मिश्रा ओनली सिंपली सेड एडजर्नमेंट बिकॉज़ इट इज द लास्ट मैटर ऑब्वियसली देयर इज नो टाइम interim order dated 9/2
9/2 last part. Type 18 2026.
Mr. Dityendu Sundar Rai for the petitioner 34 yeah?
Item number 34, I am from opposite party number 4.
1 second Mr. Jitendra Kumar Mishra -2 for the OP number से कहते सुंदर है कि जितेंद्र मिश्र कहाँ पे कही परिवे आपण
Copy number
1 and 2 जितेंद्र कुमार मिश्र 1 and 2 मैडम यूर निवेदिता बारिक
Yes, sir.
Ms. Nivedita Barik for 4. State party ଅଛନ୍ତି ଏଥିରେ?
No, no way.
State that insurance company.
Insurance. That is local अदालत matter my lord.
अच्छा अच्छा. ଆପଣ Miss Barik, you are along with some your senior.
Yes, my lord. Imjim Balapati.
तो तार ना भी लिख देबे. Miss Barik along with ना आपण ना लिखले चलिबो तो?
More of power ଅଛି.
ठीक ଅଛି. The matter being in the list could not reach during the day's proceeding. It was mentioned by the Lord Counsel, Mr. Mishra appearing for 1 and 2, OP 1 and 2, seeking adjournment. Latter, Mr. Sundar Rai, Lord Counsel for the petitioners, mentions the matter. Stop. As requested by the Lord Counsel for the OP 1 and 2, Mr. Mishra, the matter has been adjourned to 04.05 4/5/2026. Stop. The interim order dated 9/2/2026 shall continue till the has been adjourned to 4/5/2026. The interim order dated 9/2/2026 is extended. Stop. The operation of the order award para 6 रे जोटा अछि सेटा को रिपीट कर देबे ना shall not be so and so डेट हे जिवो 23/3 ता कर देबे 4/5 कले 4/5 11 11/5 कर दे. I hope you understand मुझे कहले para 6 रे अपन जोटा डेट ता अछि जोटा मिस्टर सुंदर राय कहले shall not be given effect till 23/3 जो अछि सेटा हेगला 4/5. 11 sorry 11. Yeah. Thank you. But I do not know se jodi न कहबे मु कोन करियो. Yes, the interim order is extended, but he never said that it will not be there. Nothing, he has not said anything.
Obliged.
Yes.
Thank you.